Petition for Writ of Habeas Corpus, Eric Jordan Elam, Petitioner versus Mark Agbaosi, Respondent, Warden for Dooley State Prison.
For a petition for habeas corpus relief. Ms. Worley, would you like to go ahead and just kind of tell me what the grounds were that Mr. Elam raised?
Yes, there are several grounds. I believe from my record there's 4 petitions and then petition filed. Mr. Elam is challenging his 2022 Cherokee County conviction for armed robbery. That conviction was affirmed in the Georgia Court of Appeals in case C25-A0297 on June 5, 2005. In ground 1, he alleges that the jury was instructed when he was not present. In ground 2, he alleges that there was insufficient evidence to support his conviction. Ground 3 alleges that his sentence was improperly enhanced using a first offender plea that he had been discharged from. In ground 4 alleges that he received ineffective assistance of appellate counsel for failing to raise those first 3 grounds. In ground 5 alleges that trial counsel failed to challenge the 3 out-of-state electronic search warrants in this case. In ground 6 alleges prosecutorial misconduct and misrepresentation of facts when it came to the issue of some of his counts had a null cost. Ground 7 alleges that trial counsel failed to object to the victim identifying him at trial. Ground 8 alleges that trial counsel was ineffective and that appellate counsel was ineffective for failing to raise ineffective assistance of counsel on appeal. In ground 9, he alleges that the state set up burner perjury by asking the victim to identify the petitioner at trial. From the amended petition filed this month, he alleges that he requested private counsel and had gone for private counsel but was denied private counsel. In ground 2 of the amended petition, he indicates that he informed the court on the record that he had issues with his current appointed counsel and wanted a different counsel on appeal. In ground 3, he alleges that there was a documented conflict history of his trial counsel and him before his trial. In ground 4, he alleges that trial counsel admitted to the lack of preparation before trial. When the court asked trial counsel if he had any witnesses, the trial counsel indicated that he did not. Ground 5 alleges that he told the court that he had given trial counsel a list of witnesses that he wished to call at trial. Ground 6 alleges that appellate counsel was effective in failing to investigate and locate the structural error on direct appeal, and the trial judge's court's failure to inquire into the conflict. Ground 7 was that appellate counsel had an inherent conflict of interest due to the fact that he was employed by the same independent defender's office as trial attorney. And that is all I have listed on the amendments. Certainly, if I have missed it around, I'm happy to speak correctly.
Okay, very good. Mr. Elam, are there any other grounds that she didn't cover that you want me to be aware of?
As far as the ground on getting the counselor changed, it was the appellate counsel with the trial counsel.
Okay. All right, no problem. All right, do you want to make any kind of opening statement, or are you ready to get for us to question witnesses?
Yeah, I would like to make an opening statement.
Okay.
I don't have an opening statement written down or anything.
That's
I
fine.
just want it to be as much best authenticated as I can do. Authentic. Basically, may it please the court, the petition is going to show us here today that this conviction was obtained through a miscarriage of justice. All throughout the trial, I did my best to explain to them that, I wasn't a party of the crime. And throughout the trial, we had a couple of things like text messages, because the county provided us with a church where we can text us with the counselors. And, I'm going to show evidence here today that the attorney that we that was presented, appointed to me did have a conflict.
And who was the witness that the AG's office had?
We did not subpoena any witnesses, judges. I know that Mr. Elam had subpoenaed some, I had reached out to Mr. David Clark, who was his appellate counsel.
Okay.
He is on Zoom. Also, I spoke to Mr. Justice McAdams, who is the trial counsel. He's also on Zoom. Mr. Overstreet is on Zoom. He was the prosecutor in the case. I'm not certain if Mr. Elam had subpoenaed him or not. So those are the three that we were able to contact him on.
Okay, all right. So you all didn't have these witnesses under subpoena?
Correct.
Yes,
Correct.
Okay, all right. Do you have, who do you want to call first then? If these are witnesses who...
First, I would like to call Prosecutor Damion Overstreet.
All right, Mr. Overstreet. All right, now just remember that the posture we're in, you need to ask him questions, okay? Not offer testimony, but just ask him questions that are relevant to the petition, okay? All right, are y'all ready for Mr. Overstreet?
Yes, sir.
Yeah, is it okay if I stand while I'm asking him questions, or do I have to sit
I have
down?
no problem with it. If you'd like to, you know. Good morning, Mr. Overstreet.
Good morning.
Good morning. How are you today, sir?
I'm doing well. How are you?
Okay. I am doing well. We are here for Mr. Elam's Habeas petition that he filed. And I think
Yes,
we've
ma'am.
got this. If you'll raise your right hand for me. Do you swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay, thank you, sir. All right, Mr. Elam, you may ask some questions of Mr. Overstreet.
Okay, Mr. Overstreet,
Hello?
can you hear me clear?
I hear you.
Okay, all right. So the very first question that I have for you, Mr. Overstreet. Okay. Now, Mr. Overstreet, you are familiar with the name Damion Fame, is that correct?
Correct.
Okay, now, that is the Fame, F-A-M-E. That is the alleged victim that was in this crime?
Correct.
Okay. Now, when you first took on the case, was it not an issue that the victim or alleged victim lied to you about the crime that was occurring, or that had occurred?
I think there's some mischaracterization in there. However, there were some components that, if you could re-ask that question.
The question that I'm asking you, are you familiar with the fact that the victim told your investigators that a crime occurred with shoes at first? Do you remember that?
Yes.
Okay, so at what point did he start telling the truth?
He told the investigators the truth after they began to look into his cell phone.
Okay, and what part of that process did you start believing that was the actual truth?
That there was a drug transaction as opposed to a shoe transaction?
Yeah, what made you believe that version of the story being true over the shoe deal, being the actual, what gave you the notion that he was actually telling you the truth at that point?
I've prosecuted about 100 armed robberies, and about 20 of them have been drug transactions, in which every single one of them they say they're selling shoes instead of narcotics, because victims feel that if they report that they're selling narcotics, the police will not investigate it, and they also may be arrested.
Okay. Now, during that investigation, you conducted, if I'm not mistaken, 3 photo lineups?
I did not conduct any photo lineups.
Okay, but you had 3 photo lineups conducted, is that correct?
The sheriff's office conducted photo lineups. I couldn't tell you how many.
Okay, now on which photo lineup, or which which procedure was the petitioner identified?
Which procedure he was photo lineup? I don't recall if you were identified in any of them.
Okay, I need a more direct answer. Which one of the photo lineups do you have a positive identification of the petitioner?
I don't recall, Mr. Elam.
So the petitioner was not identified in this crime.
I said I don't recall, Mr. Elam.
Okay, so if I was to like to pull up the record and actually show where you testified that petitioner was not identified, would that refresh your recollection?
Potentially. I didn't testify in this case, but if you're speaking about what I want on the record, then potentially yes.
Okay, so if I was to bring the record, present the record to you, would it help you, refresh your recollection?
Yes, it would.
Okay. May I have the time to pull the record of testimony from... Okay. Okay, what I have here, Mr. Overstreet, this is the transcript from the preliminary hearing that we had on this case.
Okay.
All right. And this is a cross-examination of you and I believe it was Investigator Tom Harris, if I'm not mistaken. And you were the one who sworn him in for the testimony. So you should have some sort of memory of this. I'm not sure why you would forget it.
Don't make little comments like that.
Yes, ma'am. Yes, ma'am.
Okay.
Sorry about that.
That's okay.
Okay, so on page 15 of the hearing, or the transcript, it states here, so he was shown two photo lineups. The first lineup was of Mr. Elam, and a photograph we had of Mr. Elam included a pair of reading glasses that he was wearing in a photo. Mr. Finn identified him as who he thought was Otto, or Otto, however he said it, because that individual was wearing, I do have it backwards. The photo that we showed of him did not have glasses on, and the individual that shot him was wearing glasses. He was unable to do a positive identification because of the difference in the glasses. Do you remember that?
Okay.
Do you remember that testimony being provided to you?
I don't have a first-hand recollection, but if you are reading it verbatim from the transcript, then that sounds familiar. I do not believe that there was a photo lineup submitted in the evidence, so that would jive with what you're saying.
What photo lineup would your investigator be speaking of here?
Apparently the one that he conducted with Mr. Damion.
Okay, so I'm glad you brought that up. Now, there was an issue as far as you suppressing that photo lineup. Where is that photo lineup as of today?
I did not suppress the photo lineup.
Okay, so where is the photo lineup today?
I'm sure it would be in our case file somewhere in evidence.
Okay, so it was in a case file, it was in evidence. Now, if it was
not in, I'm sorry, I don't mean to interrupt you, not in the evidence, Mr. Elam. Things aren't in the evidence until they're tendered at trial.
Okay, so was that photo lineup tendered into the trial of this case?
No.
Who made the decision not to tender that into evidence?
Me?
And why was that?
Because it had very little evidentiary value for the state.
So the petitioner being unidentified in a crime had very little, what was that?
Evidentiary value.
Okay, and as far as your case in that aspect, is that correct?
That's correct.
But on the defensive side, that would be considered exculpatory, is that correct?
Exculpatory, no. But it would be evidence that Mr. McAdams could use.
So it would not be exculpatory of defendant being unidentified in the crime, that would not be exculpatory, is that your position?
Yes and no. I guess you would argue that it would be exculpatory. I would argue that the additional evidence would not be exculpatory, but It was provided to your defense attorney in discovery, and we provide all potentially exculpatory evidence to your defense attorney.
Okay, so I'm glad you stated that. You said you provided it to my attorney, is that correct, or to the petitioner's attorney?
Correct.
Okay. Now, during the trial, there was a time where the petitioner got on the stand and made the statement that the photo lineup was never provided. Do you remember that? Does that come across your recollection?
Not specifically, Mr. Young. You said a lot of things during your direct and cross-examination.
Yes, sir. Now, from your testimony, you're saying that you provided Mr. McAdams the photo lineup.
We were provided everything that we had in discovery, Mr. Young.
No, I need a direct answer. From your testimony, you're saying that you provided that photo lineup to Mr. McAdams.
Everything that we had in evidence would have been provided, including that six-pack that would have been provided in discovery.
Six-pack, okay. And in that...
Six-pack is a photo of six photographs, the photo lineup.
Yes, there's just a terminology. Okay, now, in that photo lineup, just from what we just discussed here, from this testimony from your investigator, it would clearly show that the petitioner was unidentified. Unless you're saying that the investigator is lying, it would clearly show that the petitioner was not identified. Is that correct?
Was not identified in the photo lineup?
Was not identified as being a part of your crime at all.
Not to how you phrased it. The photo lineup, Mr. Diamond Fain did not identify you, Mr. Elam, or who he knew as Hudo the Kid, AHUTODAKID, which was your rap name and also the name of the person that Mr. Fain was communicating with on the OfferUp app.
Okay, and that's another thing that I wanted to ask you. Since the petitioner was not identified, your position was to keep injecting into the jury's mind that the victim was communicating with an auto, but you never had any type of direct or indication from the victim prior to that date, that trial date, that the auto of the kid that you're referencing to, which was me, was part of your crime. Is that correct?
So that's objective argument of question. It could just be rephrased for more clarity.
Yes, you may want to that question has several parts to it. If you can just try to ask kind of one part at a time, because it was confusing to me too.
Yes. Basically, what I was stating to Damion Overstreet is all throughout the trial, he injected into the jury's mind that the victim or alleged victim was communicating with other the kids. Okay.
All right, let him answer that.
So did I inject evidence that you were communicating with other kids? I think is what you want to ask. The answer would be yes. I presented evidence to show that the person that Mr. Diamond Fain was communicating with was known to him as the older kid.
Okay. Now, when you showed Mr. Fain, or not you, in that aspect, I'm speaking to you as an agent of the state. Okay.
Sure.
So when you showed Mr. Fain a photo of who you believe was father of the kid, and he failed to ID that person, at what point do you say, okay, we might have the wrong person?
Sure. At that point, I look at the evidence. I don't remember every detail, but I remember very specifics as to the evidence. I built my case on evidence. I don't base it on words alone, Mr. Elam. Why testimony evidence is the same as physical evidence. Physical evidence is what juries seem to look at too. So we took the steps to identify who this person was communicating with. We had a known phone number of who Mr. Fain said was the Hudo the Kid. We got call detail records. We looked at that information. We also found information where you, immediately after the person that's on the kid.
I would like to object to he says you. I need him to, if he states you, I need you to show proof that it was who you allege it to be. If you're going to say, make statements like that,
Okay.
You can't argue with it.
Sure. So getting back to what I was saying, we got CDRs both for a person that's who the kid, as well as Mr. Troy Cetus, who is the co-defendant in this case. Those cell phone CDR records were mapped and tracked the route, including coming to, I think it was the Walden Green Apartments, and then going back to a location. We also had evidence of I think it was an Infinity, a gold, older model, I-30 maybe, with a New Orleans Saints tag in the back. It had an Alabama tag. All of those things indicated coming back to a person by the name of Eric Jordan Elam or a family member of Mr. Eric Jordan Elam. So when we began to look at those and using the phone number communicating with Mr. Singh, who had said, "I'll be there in 10 minutes," we compared that to the CDR records, which indicated you were roughly 8 to 10 minutes from the Walden Green Apartments. And then that's how we built the case outside of having the identification specifically of you. We used that same information to connect being that was a vehicle that fled the scene that was abandoned from close to an area which was associated to your father's house. And then we also had a very interesting phone call immediately after this where a person using a Hoodoo Kid's phone called your mother.
Now, when it comes to...
Miss Lisa Elam, I think her name was.
Okay. Now, when it comes to that same phone record that you're referencing to right now, you spoke a lot there. You failed to mention that you also suppressed the actual owner of that phone record, which was an issue that come up in court now that, you guys took the procedure that you went through. That phone record, you suppressed the actual ownership of that phone record. Do you remember that actual phone record belonging to a different person other than the petitioner?
I didn't suppress any information. Let me say that. However, I think what you're getting at is did we not tender that evidence? That evidence was tendered. The entirety of the phone record was tendered. I believe I can't remember which it was. It might have been your father or your mother who that phone was registered to, but I don't recall which one. I can't say which one it was. One of the two.
So from your testimony today, you're saying that the phone record that was tendered that shows the text message between the petitioner and the alleged victim, you're saying from your position, clearly, that that phone was registered to the petitioner's mother and father. Is that what you're saying?
I believe that's who it was, yes.
Okay, and you said that full entire phone record was tendered into the evidence for the trial. Is that correct?
Correct.
Okay, so the record, the transcript did not show that you, along with Mr. McAdams, had a sidebar conversation, and also there was an objection made by the defense side to not enter the entire phone record into evidence. Would that be not true?
It's possible that there was an objection. I mean, the defense typically does object to such devastating evidence. However, so it would not surprise me if Mr. McAdams did object to tendering in that. However, the evidentiary value probably would have argued that it contains information and the jury needs to have all of the information, not just the things that we pointed out, so that if a defendant were to argue that we didn't tender exculpatory evidence or something, then we could say we tendered the entire record of everything, and we pulled out what we needed, what we felt was relevant to this trial in the case at hand. So it is a matter of pattern for me to tender the entirety, whether it be a cell phone, whether it be a CDR, which is what I did here. Whether Mr. McAdams objected, I would assume a good lawyer would have objected to this, and he was overruled, I believe.
Okay, and I'm just refreshing your recollection. There was an objection done about the phone record, and
I'm sure there was.
And if you could please not cut me off. And the judge did also, sustain that objection, and there was a suppression of the actual ownership of that phone record, and it was not the petitioner's mother, it was not the petitioner's father, it was actually the third party that no one knows who it was. And I believe that was your whole reason of actually suppressing that, to keep that out from the jury.
Your Honor, I object to argument.
Mr. Abrams, he's already testified that he didn't suppress anything. I feel like what you're saying is very argumentative.
Well, he's saying that he didn't suppress it, but there was a specific objection done during trial with the defense counsel and him, and the judge actually sustained the objection and only submitted the relevant part of the phone records into the trial.
Just make sure you're asking the questions and that you're not testifying.
Yes, ma'am. Yes, ma'am. Absolutely. Okay. Now, Mr. Overstreet. Back to the phone record. So your testimony is basically you don't remember part of the phone record not being entered into evidence. Is that correct?
I don't recall that, no.
And you don't remember the photo lineup not being sent back with the jury. Is that correct?
The photo lineup wasn't tendered in the evidence, I don't believe, by Mr. McAdams or myself.
Well, I mean, please answer this. It would be very hard for a defense attorney to submit that into evidence if it was never given by the prosecution.
Sure, I would agree.
Okay. And you're saying that from your testimony that you provided that photo lineup to Mr. McAdams?
I don't remember. Look, I know you're saying there's a photo lineup. I don't recall. Possibly there. I think there was a photo lineup. If we had that, we would have provided it. I know that there was not an identification done by Ms. Nyja Kennedy, who you also were on trial for. They hung, and for Mr. Fain, I believe both of those photo lineups were done. I recall them being done. I just don't remember specifically seeing them or tendering them at trial. I focus on what I have at trial. That's why I can talk about things that I used at trial, but things I did not use. So I don't know, Mr. Elam. If we had it, we would have provided it. That's all I can say. We provide every bit of evidence. We don't hold any piece of evidence back.
Okay, and it would be a violation of your duties if there was a photo lineup done and you was, to not provide that to the state, regardless, because you saying that I didn't see it, I didn't know about it, that is not sufficient for a prosecutor when it comes to evidence. You have to, you have a duty to disclose evidence.
At the end of the day, it is my duty. If the state has evidence, I am the state. So whether it's the sheriff's office or whether it's our office, I am the state, and so it's incumbent on me to provide all the evidence. Okay,
and if there was any error as far as providing that photo lineup, that would fall on you.
Sure.
Okay, and that is what is called a Brady violation. Is that correct?
That would be correct.
Okay. All right. I have no further questions.
Okay. Do you have any questions?
Briefly, Judge. Since there's been some discussion about discovery, could you briefly tell the court the procedure your office follows when it comes to receiving discovery from the sheriff's office and turning it over to the defense?
Sure. So I have an investigator that works with me. That's kind of his main thing, is to collect all the reports from the sheriff's office, any digital evidence that they have, just collect all of it. He looks through it. He makes the determination of if we have everything that is mentioned in the report, whether it be the investigative report or the narrative that's done by the responding officers, whatever. He looks through that. I get it. I look through it once it's time to look for a charging decision. We make additional requests if there's things that I recognize that are missing or that we don't have. And then, obviously, as we begin to gear up for trial, we continue to review throughout the course of our investigation and trial prep to make sure that anything that's mentioned that we have, that we've provided to the defense as we go. So sometimes there are some additional items that we realize we don't have. Get that to them before 10 days of trial. I don't recall if that happened in this case specifically, but again, our process is to provide everything that we have that we've been given from the SO, and then try to do our due diligence to ensure that if there are things mentioned that we don't have, that we reach out to the sheriff's office to get this provided to us.
Does your office have an open file policy?
Yes. Defense attorneys can come and review our file. Most of them do not. Many of them, I think in this case, Mr. McAdams had an opportunity to come into our office and review whatever he wanted in anticipation of trial, including physical evidence, because there was some physical evidence. I think the only thing he did review was the recreation of the plotting of the call detail records that were done by my investigator. So we do have an open file policy. Mr. McAdams had an opportunity to come review anything that we had.
If Mr. McAdams had reached out to you and indicated he did not have a copy of the photo lineup, would you have made sure he was provided with a copy?
Absolutely. I know Mr. McAdams well. He actually was gracious enough to get me to appear via Zoom because I was driving to Dooley County today. So if Mr. McAdams needs something, he can reach a cell phone, so there's no reason why he can't reach out to me.
All right, you mentioned on drug examination that Mr. Fain was unable to identify Mr. Elam in the photo lineup because he was not wearing glasses. I'm asking you to think back a little bit here. Do you recall if Mr. Elam was wearing glasses at trial?
Well, I believe Mr. Fain identified Mr. Elam at trial. Whether he was wearing glasses, I don't know. I don't recall. So I can tell you some of the issues we were running with into the identification part was there were two people in this vehicle when this armed robbery occurred. Mr. Elam was sitting in the front driver's seat. Mr. Fetus, the co-defendant, was sitting in the front passenger seat. So it required Mr. Elam to turn at that, so you had a side facial profile of Mr. Elam. The glasses that Mr. Elam had on were very particular. I think they weren't framed on the lenses, and so we had some discussion. But after at trial, I don't recall if he had glasses at trial, but Mr. Fain was asked if he saw the person in court, and he identified him at that time. He was not shown anything by the state or any additional photos of Mr. Elam. That was just something that we did to see if.
And I don't know if you're able to see on Zoom, but for the sake of the record, can you see if Mr. Elam was wearing glasses today in court?
He is. They appear to be dark, black-rimmed glasses. They're not the same as what he had on. The ones that we believe he had on, these were open-framed, and I think they had some gold accenting to them as well. I believe they were consistent with glasses that we had found on his social media as well, which was another factor. I could be incorrect on that, but I believe that was a case.
Yes, I would like to recall. All right. Now, she brought up a couple of things that shedded light on, a few questions that I may have left out. You stated that Mr. Fain identified a petitioner in trial. Is that correct?
I believe so.
Now, during that part of his testimony, when you asked him that question, if he can point out the person who allegedly robbed and shot him, did you know what the answer would be to that before you asked that question?
No, I did not, because I believe he did not identify you specifically, but again, based on my prepping with him, I understood the angle of which he did. Me kind of showing what I just did on this Zoom call, how the transaction went down, where he was like that, the gun was pointing just like that, he was shot because he was sitting in the back seat of your vehicle, Mr. Elam's vehicle. He was sitting in the back of that vehicle, and he was shot. So I had a partial view from that angle. So I did not know what his answer was going to be. Probably not the best thing to do to ask a question by a prosecutor you don't know the answer to, but based on the other evidence, we were confident that he would be able to positively identify Mr. Elam. Okay. Now, and also, she asked a question as far as, well, you made a statement as far as the type of vehicle. Being an Infiniti i30, are you familiar with the windows of that Infiniti being tinted? Do you remember? There was some tint on that vehicle. I'm well aware of that vehicle because we also had a photo, videos on social media from the co-defendant where he was in that vehicle. I believe it was a day or two before with a gun. He was also wearing a similar shirt in that video to his arrest photo. When he was arrested for this crime, I think it said like High on Life. It was black with gold writing or something. I saw that video many times, including you sitting in the vehicle, rapping in the vehicle. I think we had a lot of social media from you, so your connection to that vehicle was very well known to me. Okay, and this proceeding is a constitutional court. It's not about innocence or guilty things or anything like that. Now, as far as
the first time in court identification procedure. In Georgia, it's permissible. You can do it, but it goes by the totality of the circumstances, and it's a credibility issue for the jury to decide. Okay. Your alleged victim testified in trial that the alleged perpetrator turned to the left. If you're alleging that the petitioner was in the driver's seat, you have a window here, okay, and you have a seat right behind you. So if the perpetrator was to turn to the left, and you're stating that turn to the left and shoot the victim, and then you have a victim that you present this photo lineup of the alleged perpetrator, and he cannot identify them. Okay, that goes against the exact problems that the first-time identification procedure.
Judge, I'm going to object. It sounds like argument as to the sufficiency of the evidence. The jury has already made that determination.
I don't mind the question, just kind of break it down where he can
Yes,
kind of answer one part at a time.
Yes, so basically, for a first-time identification in court, what is necessary for you, as a prosecutor, what is necessary for there to be an evidence in order to use a first-time identification in court?
I mean, for me, it's a compilation of all the evidence that I have. I mean, ideally, yes, Mr. Fain can identify the defendant from the stand who committed this, then great. However, we had some issues with that. We were unsure if he was going to be able to. That's why we spent the time going through the cell phone. We spent the time connecting the name of a Who Knew the Kid to Eric Jordan Elam. We spent the time connecting that phone being used that tracked the routes of Eric Jordan Elam along with Troy Fetus together, both to the Walden apartments. So we didn't have the best identification per se. That's why we spent time using the digital evidence to connect that phone, that car, that name to Eric Jordan Elam so that the jury could see who in fact Eric Jordan Elam was.
Okay. And it seems like you have a refresher recollection since you stated the evidence and connection. What exactly connected with the evidence that you stated that you have? What's in the records that you received connected Petitioner to the records of the cell phone? What do you have that connected to you?
To connect you to the phone?
That connected.
Oh, well, I'm sorry, connect Petitioner to the phone. Let me see. We had Troy Fetus' phone. I
asked exactly what in the phone record connected the petitioner to the phone.
The location information connected you to the phone. I think you had access to various there's photographs, I believe, to the phone. I believe there are multiple things that connected you. Again, you have multiple law enforcement tools to search numbers associated with people. That was one thing. I don't recall the specifics of what in the CDR's call detail records were specifically to you, because again, I do believe it was the name on the account was somebody else. However, we did track down that phone number using Troy Fetus' number, who was the co-defendant in this case, who pled guilty and testified at trial, and other resources. I don't recall exactly what they were, but when we got that information, it did all link back up to Eric Jordan Elam.
You said it did.
It did.
Okay. Well, now what is the it did part? What links back up to the petition? Because you in your testimony, you keep saying a lot of things, that bolsters the whole. Not even going to get into that, but what connected the petitioner? You keep going around in circles. I need to know exactly. I need for you to state on the record what exactly connected the petitioner to the phone.
It was not just one thing. It was everything.
Okay.
It was not just one thing. It was everything. Again, all of these various things connected you. The car was a big factor. I believe you were living out of this car at the time that this incident happened. You had a co-defendant who identified you as well as being involved in this. So those were some of the aspects that also connected this case.
Okay, now, I'm glad you stated that. So, in this case, was you not informed that there was a report on a car being stolen?
Yeah, after the fact.
That's not what I asked you. Was you not informed that there was a report of the car being stolen?
Yes, I was informed that the car was stolen. We looked into that, and it was determined to have been reported after the fact by Petition. The owner of the car was your father, Jerome, maybe?
Okay, so
I could be wrong there.
You said the owner of the car. So every time you stated previously in your testimony, you stated the car was mine, right? Now, you are a car owner yourself, right? You do understand that if you're not the owner of a car, you cannot make a report on that car being stolen. It would actually have to be the owner that goes and makes a report, hey, my car is stolen. It can't, you can't have your friend go to the police department and say, hey, my friend's car was stolen, or this party's car was stolen. It has to be the owner of that car, okay? So,
I'm not aware of that, but okay.
all right. So, basically, you're saying that there was a report of the car being stolen. Is that correct?
Yes, there was.
There was a, okay. All right, now, at what point was you going to release that information for the jury to decide?
I put out evidence that I think is relevant. Whether the car was reported stolen, that would have been a decision your defense attorney could have made.
So in a case where you have a person that's not identified, and in a case where you have a petitioner telling you that the car was stolen and that the parties that was involved, you don't have the correct parties, that would not be relevant to that type of case? Because your job is not to get a conviction. Your job is to basically find the facts of the case. Is that correct? Your job is not to just get conviction.
My job is to seek the truth, Mr. Elam.
Exactly. Your job is to get the facts. Okay, so in coming to a point of finding the fact, would it not be reasonable for you to release that information to the jury so they can decide, okay, is there a reasonable doubt? Is this a misidentification? Because that's what you had. You had a problem with identification, and you used a lot of outside bowstrings to point at someone that's impermissibly suggested. When it comes to a first-time in court identification.
Just again, I'd ask that Mr. Elam ask a question that Mr. Overstreet can actually give on.
Just keep in mind that, all of these questions, you don't need to go into the sufficiency of the evidence. If you have any kind of, ground that it was probably one of the specifically asked about those things.
So I'm going to stick to the suppression of the photo lineup because I believe that it has a lot to do with this. In your testimony, or in your alleged victim's testimony, you asked some questions regarding, the parties involved and things like that, and specifically with Nyjah Kennedy, which was the first alleged victim. For some reason, you asked her if she was able to do an identification, and she answered no. And the outcome of that case, there was a full exoneration, full not guilty. Now, when it comes to and to pinpoint, she actually showed up to court in orange jumpsuit. She was arrested, and it came out that she didn't want to testify or continue prosecuting the case. And for some odd reason, she showed up to court in jail in custody. When it came to Damion Overstreet, you asked a question as far as a leading question, if he can identify the person who robbed and shot him. And I kind of want to go back to the question that I asked you earlier as far as if you knew the answer to that question. What made you ask that question? If he can point to the person that robbed and shot him, what made you ask him that question and not ask in that shape, form, and fashion, and not saying like the first victim, because it was the same type of issue for both victims. What made you ask him that and not ask Nigel Kennedy that?
I don't recall. I think I felt like I did, but maybe I didn't ask her. I don't recall. It might have been that she definitely was confident she could not remember or identify who you were. I believe in that situation, it was in the parking lot of Walmart. It was the same scenario where they were in the back seat, but then somebody slid in next to her and said, "Run them pockets," I think it might have been what was said. And so the person in the back would have been Mr. Fetus, who she was able to describe more particularly. The respondent, Mr. Elam, were in the front driver's seat of that vehicle, did not turn around, so she was not able to identify you, if I recall right. Additionally, I had one different thing you asked me, luckily, well, probably not helpful for the court, but I might be able to try to figure out how to share my screen, but I pulled up my evidence in this case, Mr. Elam, so because you asked a question of how we were able to identify you. There was a 404B in relation to the phone records. We were able to get your phone record and attribute it to you because the person who you were involved in, we filed a 404B where there was like a robbery of another person who testified at trial. There was an amount of money that was sent from that person's phone to the phone number 678-353-9449. And so that was part of how we were able to begin an investigation as well and connect a phone number to Mr. Jordan Elam as well. So that was, you asked that question, I wanted to follow up and make sure I was able to give you an accurate answer. So that was some of the information that we also had to connect you to that vehicle, because he described that vehicle as well, as also, he also has your phone number.
Okay, now you stated that you used the 404B motion, that is basically like when you run intrinsic evidence or same transaction evidence, is that correct?
Correct. So that with him, I believe I said that was the 404B was a separate incident. But it was in close in time. So I think I filed 404B, but I argued it was intrinsic because you had 3 armed robberies that occurred within less than a week period back in February. So I believe I argued it was intrinsic, but I also filed a 404B motion to have that tendered and admitted evidence as well.
Okay, and since you ran the evidence intrinsic, the full exoneration of the first armed robbery, that shows that the evidence in your case was theoretically weak. Is that correct?
The evidence was weak?
Yes. From the full exoneration of the armed, you stated that you ran your evidence intrinsic with the 404B motion.
I think the facts before the court would say the evidence is not weak, Mr. Elam.
Okay, so basically the theory had some deficiencies because the jury obviously didn't agree with that with the first armed robbery. That was a full exoneration, full not guilty. Okay, and with that being stated, it shows that the evidence that was in dispute was weak. So my question for you is, you just showed me something. You're able to pull up documents on your computer. Is that correct?
But I saved my evidence for my trial in PowerPoint form.
Okay, that's good. That's good. Can you show me, or can you present to the court the photo lineup of Damion things?
This is my PowerPoint that I used at trial. I did not tender that into evidence, so it would not be a part of this.
You just stated earlier in your testimony that you have your evidence in your laptop that you're on right now. Can you pull up the photo lineup of Damion things?
I just answered that question, Mr. Elam.
Okay, after. All right. So I have no further questions for him.
Okay, anything further?
Briefly, Judge. Mr. Overstreet, even if Mr. Fain was never able to identify Mr. Elam, were you still confident that you had enough evidence to prove that Mr. Elam was guilty beyond reasonable doubt?
Absolutely.
Anything further?
No questions.
Okay. Do you have any objections to this witness being excused from the proceedings?
I do have an objection because I might have further questions for him after I get done talking to Mr. Clark. So I would not want to fully give him the eject because I might have further questions for him later.
I'll stay on, Your Honor, it's fine.
Next, I want to present to the court Mr. McAdams.
Good morning, Mr. McAdams.
Morning, Joe. I'm good, how are you?
Good. I apologize that you had to be on hold this long. We didn't get everybody here on time this morning, but we've been trying to go as quickly as we can. Mr. Elam is here from his Habeas Petitioner and has some questions for you, okay?
Yes, Your Honor, I can barely hear y'all. I'm trying to turn up the volume on my machine, I don't know.
I'm going to speak it. Will you raise your hand? Or turn your
I do?
Okay, thank you so much. All right, go ahead, Mr. Elam.
Mr. McAdams, can you hear me clear?
I can hear you much better than I can hear the judge. I don't know what's up with that, but I can hear you.
Okay, so you did hear her swear you in, is that correct?
Yes.
Okay. All right, you were the trial attorney for this petitioner's case, was it?
Correct.
Now, first things first, in the beginning of the trial, there was a discussion between the judge, the petitioner, and yourself. Particularly, you chose to bring up in the courtroom that there was some sort of conflict between you and the petitioner. Do you remember that?
Yeah, I remember discussing with you that you could have a satisfaction of attorney hearing for the judge, and for your grievance.
You're kind of skipping there. I want the record to be very clear. If you can please check that for me.
Working on, I can see y'all.
Yeah, you're kind of skipping there, Mr. McAdams.
Mr. McAdams, we didn't hear anything that you said. I'm going to let Mr. Elam re-ask that question. Do you remember what you asked him?
Yeah,
Okay.
Okay.
Okay, so in the beginning of the trial, you specifically stated for the record that there was some sort of conflict. Do you remember that?
Yeah, I remember discussing with you that you could have a section of hearing judge.
No, not discussing with me. For the record, during trial, you specifically mentioned to the judge that there was some sort of conflict. Do you remember that?
Yes.
Can you please restate that answer again?
Doesn't seem like he has a good internet connection.
Would you like me to log out and log back in, Your Honor?
Yes, sir. Are you on your cell phone?
No, I'm on a tablet on my desk here in the office.
Okay. Well,
I have gig speed at the office.
okay, well, we can hear you now, so I'm not sure what's going on.
I can try.
Yeah, you want to try again? Okay.
Okay, so, again, you stated that you spoke with me, which, you know, I don't dispute that. I'm specifically asking you about the statement that you made to the judge. Do you remember telling the judge that there was a conflict that you was having with the petitioner?
I don't recall the conflict. No, we had a satisfaction of attorney hearing. Judge, if it's okay with you, I'll log out and log back in.
Yes, sir, that's fine, thank you.
And while we're waiting on that, if I'm going to be presenting this exhibit here today, is it okay if I give a copy of that to you and to the...
Yeah, well, she would need that, Ms. Worley would need to see it first.
It could be.
Let's try this again. Okay.
All right, Mr. McAdams, can you hear me clear?
I can hear you, and I'm on a different device, so hopefully this helps.
Thank you.
Do you remember the question I was asking, or do I have to re-ask?
Yeah, you asked me if I said on the record that there was a conflict between you and I, and my answer is that I don't remember saying that there was a conflict between you and I. I remember having an attorney satisfaction hearing in front of Judge Bishop on the record before the trial.
Okay. And if you don't mind, if I can state, I have the transcript here, if you don't mind if I state for you, because I'm going to ask you something about, you know, this insert once I'm done reading it, if you don't mind, if I do.
Judge, can I have a page number so I can follow along?
Sure.
Yes, exactly. This, page 2, it starts off on.
This is the trial record?
All right, here it states under McAdams, under line 15 is where it starts. It says, Your Honor, Judge McAdams, on behalf of the defendant, I am appointed on this case. I have been on this case since Mr. Elam was booked into the Cherokee County Jail. He has been in our jail for over a year. He was in custody in DeKalb and Gwinnett before that. He's been in continuous custody pretty much since the alleged incident. I've gone over discovery with my client. I went to the jail, brought my laptop over there, went through digital discovery, had paper discovery pretty much as soon as I got it. And then after meeting with him, I got a call over the weekend from somebody saying that they were going to make his bond, and 2, going to hire him a private attorney. So I wanted to bring that to the court's attention, make a record, and allow my client to be heard. He's asked me for a continuance. I'm ready for trial. I'm not asking for a continuance, but of course, my client would like to be heard. When you say that there was someone who called, do you remember who called you?
No, I don't remember who called me.
Do you remember exactly what was said to you on that call? Or roughly?
No.
You said no?
No.
Okay. Okay. So, here, under the record, and I'm going to page number 4. Page number 4. It starts to break down as far as the judge, speaking about filings that were filed previously to the trial, and specifically, he brought up the motion to withdraw. You remember that being filed?
I don't recall filing a motion to withdraw ever.
Do you remember the affidavit that was filed by the petitioner to withdraw you from the case?
Oh, no, I don't remember what specifically you filed.
Okay, so from your position here today, you don't remember there ever being a motion to withdraw or anything like that?
So an attorney files a motion to withdraw in a case.
Okay.
So you're not an attorney, you're the defendant.
Okay,
So that's why
from your
I never filed a motion to withdraw. I was appointed. On appointed cases, I'm supposed to stick with it unless there's a legal conflict, and there wasn't.
Okay, so from your position, you're stating that you don't remember there ever being an affidavit submitted to withdraw you from the case?
No, I don't remember specifically. I know you filed a lot of pro se stuff.
Okay. But specifically, you don't remember about an affidavit in support of the motion to withdraw?
No. And again, an attorney files a motion to withdraw. I never filed.
That's correct, but I'm stating about an affidavit in support of a motion to withdraw.
Yeah, I don't remember what you filed.
Okay. All right, so during the pendency of this trial, do you remember contacting the petitioner through the church? You remember, requesting for copies of that church transcript? Do you remember doing that?
Yes.
Okay, and when did you provide that to the petitioner?
I couldn't tell you.
I don't need the exact date, but I'm saying, was the petitioner incarcerated whenever you provided that church transcript?
Correct.
Okay. Now, specifically, and I provided this technically too as well, specifically, there was some communication between you and the petitioner during the pendency of this case, and specifically directly after the preliminary hearing. During the preliminary hearing, you do recall the state saying that your client was not identified in the case. Is that correct?
Yeah, I think the identity came later.
That's not what I asked you. I asked you, you specifically remember the state letting you and the petitioner know that there was no identity in the case. Is that correct?
I don't know what the state said. Are you talking about during the hearing?
Specifically during the preliminary hearing in this case, the very first opportunity that we had, because, you did get the option to either waive preliminary hearing and file for discovery, or to go to the preliminary hearing. Is that correct?
Correct.
Okay, and when you went to the preliminary hearing with your client, that was the very first time that you learned that the petitioner was not identified. Is that correct?
So the identity came later.
That's not what I asked you.
You have to explain, sir, but you asked a question. Let him explain his answer, okay?
At the PC hearing, you were identified.
Okay, so you said at the PC hearing I was identified.
Yes, otherwise the warrant would have been dismissed.
Okay, all right. I'm glad you stated that. All right. So at the PC hearing, you said I was identified.
Yes. that there would have been an in-court identification that would have said, you know, defendant is sitting at the counsel table in, you know, whatever color jumpsuit.
Okay, and this is just hypothetically, if I wasn't identified, by you being a trial counsel, if I wasn't identified at the PC hearing, that would be incompetence, right?
No, that wouldn't be incompetence.
It wouldn't be incompetent if your client wasn't identified, and to have you say that your client was identified, that wouldn't be incompetent?
So your case was subsequently indicted, and they identified you in the indictment.
So when I say identity, I'm not speaking about name being on the document. I'm talking about specifically being identified by the victims, the alleged victims in the case. So
It doesn't have to be victims, it can be by officers testifying about who Eric Jordan Elam is.
okay, so sir, again, I'm going to restate my question here. I'm not specifically talking about identity on a piece of, on a paper. I'm speaking about specifically being identified by the victims themselves.
You weren't identified by the victims themselves because the victims themselves don't testify at the PC hearing. If you were an attorney, you would know that.
Okay, so at the PC hearing, that is your testimony that the investigator said that the victims, the alleged victims identified the petitioner. That's what you just said earlier, is that correct?
That's not what I said.
Okay, so when you stated that the petitioner was identified at the PC hearing, what are you referring to?
By the officer's testimony.
Okay, so the officer's
And by identifying you in the courtroom.
okay, so from the officer's testimony is what you're saying I was identified by.
Yes.
Okay, so it would
There's no other testimony but the officers.
okay, so just in question as far as competency, right? If you are the trial attorney, and this is a compound question, if you are the trial attorney, and you overhear from an investigator that your client was not identified, and you have a trial attorney saying that the client is identified, that would be a conflict, would it not be?
So, if you're identified by an officer, then that satisfies the requirement in the PC hearing.
Sir, that's not my question. I'm asking specifically about you. If you are the trial attorney, and you overhear from the investigators themselves that your client was not identified, and you, yourself, the trial attorney, say that your client is identified, even though the evidence say that your client is not identified, that would be a conflict, would it not be?
So, we're not trying the case at the PC hearing. The PC hearing is for probable cause.
That's correct.
So, if the officer can testify to your car, which you were driving,
That's correct.
and cell site data, and other people's testimony about who they were going to meet to buy weed, and that kind of thing, and then they can identify Eric Jordan Elam in the courtroom, then a magistrate can and did make a decision that you were identified for probable cause purposes.
Okay, so I'm going to ask you this question, Mr. McAdams. You did go to law school, is that correct?
Yes.
Okay, so that is a very, very difficult thing to do, is that correct? To pass, bar exams and things like that?
Yeah.
Okay. So I'm going to ask this question to you again. If at the probable cause hearing, investigators state that your client is not identified in a case, okay? And for you, yourself, the trial attorney, to say that your client is identified after learning that your client is not identified, is that a conflict, is what I'm asking you?
I guess I'm unable to answer your question because you don't understand what identity is, and you don't understand what the legal concept is.
So I'm not asking you any type of legal questions. I don't need any type of legal advice. I'm asking you, is it a conflict? Sir, don't cut me off, please. Sir, don't cut me off, please.
Mr. Elam, you cannot argue with your witness.
I'm asking him.
You're arguing with him.
Yes, ma'am.
One thing I need you to do is this line of questioning in relation to your ground that he was ineffective, because that's not clear to me right now.
Okay,
I feel
so
like
the
you're arguing
question-
with him about the evidence, But what you've got to do is you've got to ask him questions that help me to understand whether or not he's provided ineffective assistance, okay?
So what I'm trying to establish now, Your Honor, I deeply apologize.
That's okay.
I'm trying to establish the whole issue in the beginning of the trial that we had, which was the conflict
Between you and him?
between the petitioner and the trial attorney.
Okay. But whether there was conflict or not a conflict, what you've got to do is you've got to demonstrate that your constitutional rights were deprived because he was ineffective in some way. I'm not hearing that.
Yes, ma'am.
I'm not trying to tell you how to position
so
it, but I'm
basically-
not hearing that.
So basically, the issue that we have, the constitutional violation that I'm presenting here with this evidence is a violation of the Sixth Amendment. Provides me the right to not only effective, but a lawyer that helps, making the trial fair. If there's a conflict with the attorney, it affects the adversarial process, okay? And there was a conflict between the petitioner and Mr. McAdams. The conflict comes in when you have the state saying that you're not identified, and to have your trial attorney say you are identified.
But what he's saying is that the judge found that there was probable cause in this hearing, so I think I'm just confused as to why. I mean, you can keep asking him questions, that's fine. I just, in your mind, you need to ask questions that would illustrate whether or not he was effective.
Yes, ma'am. May I approach you, Goodbye?
Has Ms. Worley seen the document?
May I approach?
Well, has she seen the document?
Yes, ma'am.
Oh, okay.
That is a church transcript that Cherokee County provided. It is a document that can be requested through open records. It is also admissible by party opponents. There is text messages from Mr. McAdams and me, myself. There you see Mr. McAdams saying that the victim...
Just before this is run to the record, I heard policy disability.
Yes, you may.
First of all, I'd like for Mr. McAdams to be able to authenticate it if these are actually text messages from him. It would not be admissible under party opponent. The party opponent in this case is the warden. Mr. McAdams is here under Mr. Elam's subpoena, so he's not a party opponent in this case.
I can ask you that question if that is for me to do.
Yeah, you can ask him questions about the document.
And then once he's able to, because I asked him already, he already admitted that he provided the church transcript. So I can ask him again for the record if that's needed.
I mean, are you going to ask him questions about this document?
Oh, no, because it's already been established earlier from Mr. Overstreet's testimony that I wasn't identified. Now it's just establishing the conflict that I had with him, saying that I was identified after having personal knowledge that I was not identified. So there was a conflict between me and an attorney. I'm telling him from information that I knew that I was not going to be identified because I wasn't a part of the crime, and also information from the evidence showing that I was not part of the crime. For you to say, hey, no, you're identified by people that have already shown that I wasn't identified, that's specifically why I asked for the Carolina. You, the attorney, saying that I was identified, the evidence saying that I'm not identified, that's a conflict.
Okay. So you can ask him about it.
Mr. McAdams, just before I get into my next set of questions here, the text messages between you and I on the church transcript, when you texted, you were ID'd by the girl in the car that was robbed, and you were ID'd by the guy who got shot, and you were ID'd on the hit and run by the car in close proximity to the two armed robberies. When you said ID'd by the girl, first...
Can I ask that we first have Mr. McAdams authenticate that he did, in fact, do the text message?
That he did what?
That he did, in fact, the text message that was from him to Mr. Elam. We haven't had authentication on the record yet of this document.
Mr. McAdams, you were texting me back and forth on the church device, was you not?
Yes.
Okay, your records, I did receive some records from complaint that was filed with the Georgia State Bar. The director did provide me with sort of a timesheet of when you were texting and when you wasn't texting, and also I have the church transcript here that shows your office number and also the church number, corresponding with each other. So you do remember texting me back on that day, is that correct?
Yes.
Okay.
You wanna, what's the phone number? You might not ask the receptionist phone number.
Yes, 770-894-4194, I believe.
824.
Yes.
4194.
Yeah, 4194. That is your number, is that correct?
Yes.
Okay.
Is that Petitioner? Yes, okay, thank you. Okay.
All right, so you text the petitioner that you were ID'd by the girl in the car that was robbed, and you were ID'd by the guy who got shot, and you were ID'd on a hit and run by the car in close proximity to the two armed robbers.
Yes.
You text that. You remember texting?
Yes, I did.
Okay.
I did text that.
Okay. So what was your reason of saying that? And this was a few days after probable cause hearing, a few days after hearing that your client was not identified. What was the reason of texting your client there?
So I've been trying to answer your question from the PC hearing. You were identified in the PC hearing.
Okay, but specifically here, your text messages say you were ID'd by the girl in the car. You were ID'd by the guy who got shot, and you were ID'd by the car in close proximity to the two armed robbers. I'm not asking about legalities on what can be used as identity. Specifically, you said I was identified by the alleged victim.
Yeah. The alleged victim, the girl from the Walmart, knew you. Okay? You bought weed from her, she knew you. The folks from the hit and run identified the vehicle. They gave the tag number and the make and model of the vehicle. They followed the vehicle down the road and were on the phone with 911. And we were identified by the police work on the other armed robbery and ag assault, which you were subsequently convicted of. Okay.
So you're kind of averting the question. You specifically said that I was ID'd by the girl, okay? You said I was ID'd by the person who was shot, and I was ID'd by the alleged hit and run, all right? Where in the evidence did you get that information from?
That would have been from the preliminary police report and the hearing that we went through, the PC hearing.
Okay, so from the preliminary hearing, is that correct? Okay.
Yeah.
So I'm going to read again for you the testimony of Investigator Thomas Harris, and I want you to answer a question that I have for you after that, okay? Yes, again, this is from the preliminary hearing.
And what date was that held?
That was held, that was on March the 5th, 2020.
Judge, I would ask for a full copy of transcripts to be turned into evidence before we read portions of it. That's not one of those exhibits that we were intending to tender. It's not one of them, is that on there? Okay.
She has a copy. She has a copy of it.
Do you have a full copy of the transcript from the preliminary hearing?
She has it.
I'm asking if you have.
I have a full copy of it here.
Okay. I just want to be tendered in evidence to know the full context of the transcript.
Okay. But you don't have a copy of it?
Not what they did, it's not one of the ones we were intending to test.
That's the copy I just saw. There was a front
She
sheet.
said she doesn't have it, she doesn't
I
have it.
have preliminary motions from March 10, 26. These are the county motions here for the lead. Make sure we have evidence.
Is that not from March, this one?
No, it's March 10, 2024.
If you want, you have to make a copy and submit it, or can I still present?
We did that for a life sentence. I just feel like this was an
I
easy
don't have a
one.
copy of it,
Like you had a prior.
Because I only have one, being incarcerated is very, very hard to get a copy.
okay. Why don't you,
I'm gonna let him just ask questions about it, but you don't have a copy to verify this, is that what you're saying?
No, we pulled the record from the Court of Appeals, and that was not one of the transcripts that was transmitted off with the Court of Appeals.
Okay.
So, it's not one that we were intending to tender into the record for this case.
I gotcha. Do y'all have a way to make a copy of that, or electronic? Okay.
No.
Yeah.
Yeah, do you want to just hold off on the question until?
Because I don't mind that questions are asked of it, I just want, for the sake of the habeas record, to have a full, complete transcript be tendered in. So I have no objection to that. I would object to any handwritten notes, but I, you know,
Do you want to, are there handwritten notes on there?
Yes, ma'am.
but, I mean,
Yeah.
I would be fine with, I guess, like, a constructive redaction of those, like, it's not to treat any of the actual handwritten comments as evidence.
Yeah, the handwritten things, I don't mind, we can leave those out. It was just things that to highlight for your point of view.
Do you want a copy to follow along while he's asking some of these questions?
That's fine, we can do it after this.
Okay, we'll do it after. Okay, go ahead, Mr. Green.
Thank you. All right, so specifically, Mr. McAdams, there was part of that hearing where both victims, or not both victims, but the investigator had to testify in reference to both victims. Okay? And specifically, the investigator testified that your client was not identified by both victims. Okay? And my question is, if your client was not identified by both victims in the case, and I'm going to read the testimony exactly, okay? So he was shown two photo lineups. The first lineup was of Mr. Elam, and the photograph that we had of Mr. Elam included a pair of reading glasses that he was wearing in a photo. Mr. Fain identified him as who he thought was Otto, however he stated. Because that individual was wearing, I do have it backwards. The photo that we showed of him did not have glasses on, and the individual that shot him was wearing glasses. He was unable to do an identification because of the difference in the glasses. Okay, that's for the Diamond Fame case. For the Nigel Kennedy case, it states here that she was presented a photo lineup, and she also failed to do a photo lineup. Do you remember that?
No.
You don't remember both victims failing to ID your client?
From the photo lineups? No.
You don't remember that?
No.
Okay, so if you are an attorney and that is presented to you by the state that both victims failed to identify your client, and you don't have any recollection of it or have any knowledge of it, that's not a deficiency?
No, I wouldn't say it's a deficiency. That was about 5 years ago. If that's what it says in the transcripts, and that's what the officer said. But again, you were still identified by police work by a probable cause standard at that point. If you were not identified, that warrant would have been dismissed.
Okay, so clearly it states here that in a probable cause hearing that I was not identified.
Well, you're limiting it just to the photo lineups.
No, the whole procedure states that I was not identified. If we have to, we can brief the whole record. And the investigator specifically stated that your client was not identified in his claim or in the case. So the question is not about if later on police work misidentified someone. That's not the question. The question is, if you have first-hand knowledge from an investigator that your client was not identified by the two alleged victims, what made you text your client that he was identified before any police work is done? Because we're talking about the same time now. We're talking about preliminary, March the 5th, 2021. You sent these text messages 5 days after that hearing saying that your client was identified, even though you just heard that your client wasn't identified. What was the reason of you sending those text messages?
Because I understand the legal definition of an identity. It doesn't have to be in a photo lineup specifically. You were identified at the PC hearing.
Okay,
by
the
police.
victims or by police work?
By police work.
Okay, so again, the text messages specifically states that you were ID'd by the victim, the girl, you were ID'd by the male, and you were ID'd by the 2 cars in close proximity. That doesn't sound like police work.
You have to ask the question.
Does that sound like police work to you?
That's how you were identified, by police work.
Okay, so specifically again, Mr. McAdams, your text messages say you were identified by the victim, the girl victim, identified by the male victim, and identified by the car in close proximity. Does that sound like identity from police work? No,
That's their next answer.
okay. Okay, so the text message that state you were ID'd by the girl that was robbed, that was preliminary, okay? When this victim was asked a question about identity in the courtroom, you specifically asked Mrs. Kennedy if she was able to do a photo lineup. Do you remember asking her that? That was part of your defense?
Yeah, that sounds familiar. That might have been how you won on that count.
Okay, so part of your defense, for the record, you stated that that's how I won on that count, or how the petitioner won on that count, by you asking the question if she was able to do a photo lineup?
Well, I said probably. I don't pretend to get into what was discussed in the jury room between the jurors about that count. But weren't you acquitted of that count?
It is a high possibility that that particular question is what caused or created the reasonable doubt. Is that correct?
Speculation.
He's already said he doesn't know what kind of discussions took place in the jury room.
Yes, ma'am.
Yes.
So, okay, so you asked the first victim about the photo lineup, and she answered in the negative, saying that she was not able to do an identification. I believe this would bring up the next question. I did ask Mr. Overstreet, the evidence in this case, as far as, I understand that we don't have the attorney-client privilege anymore or anything like that, but from your aspect of it, this case, the evidence in this case was weak. Judging by your closing statement in the case, the 3-legged stool thing, this case presented fairly weak evidence. Is that correct?
So, yeah, I'm making that argument in closing argument. Like, do I believe that with everything that I saw? No. But I'm making that argument for you as your advocate, and for the most part, it worked. It just didn't work on count 1.
Okay. Well, it didn't work on count 6.
Okay.
Okay. Now, and I'm glad you stated that. It worked. Your strategy worked fully on the alleged victim in count 1. Now, when it came to count 6, or the victim in count 6, during the testimony of that victim, you asked that victim a couple of questions, and there was a couple of questions that you left out that worked on the first victim. You asked the victim if he was able to do a photo, if he did a photo lineup. You asked him that question. And specifically when he answered yes, you had no further questions for the victim. What stopped you from asking him that same question that you asked the first victim if they were able to do an identification?
I don't remember specifically, but I can tell you that the burden's on the state. If the state had a photo lineup the day where he positively identified you, then the state would need to put that in. The burden's not on me at all.
Okay.
And so I'm not going to open the door for Mr. Overstreet to come back and add anything. But I don't remember specifically why I didn't ask that alleged victim why he couldn't identify you or could he identify you. I didn't want it to get into, I think maybe one of them said 60%. I just don't have it in front of me, don't remember.
Okay. And you stated something about a burden. You said the burden was on Mr. Overstreet to release the information or the discovery as far as the photo lineup. Is that correct?
Oh, yeah, well, no, I was discussing the burden of proof. The state has to prove that the victim can effectively identify you.
Okay.
And so I'm not going to open the door for Mr. Overstreet. I'm not going to do him any favors on his burden. So I can't answer that I recollect 100%, but that might have been why I didn't ask the follow-up question.
Okay. So you didn't ask the follow-up question as far as the victim, and I just want the record to reflect clear that you asked the first victim if she was able to do a positive identification, and she said no, but you did not ask that question to the same case. Is that correct?
If that's what the transcript says, then that's correct.
Okay, that's what the transcript said. I would like the record to reflect that. So, whose duty is it, let's say, for example, if you did a photo lineup, whose duty would it be to disclose that information or disclose that document? Is it your duty to disclose that information or to submit it to the jury, or is it the prosecutor's job to submit that to the jury?
So I object on the grounds of asking Mr. McAdams the formal legal conclusion. Objecting to say, we want to another.
Okay, so is there any way possible I can ask you in different forms?
You can ask.
Okay.
We'll see if it's next question.
Okay. So, the duty for, when you conduct a photo lineup, that is part of evidence, is that correct?
When law enforcement conducts a photo lineup, it can be part of evidence.
Okay, what I'm
It
asking...
doesn't have to be part of evidence. The state doesn't have to put it in. I don't have to put it in.
So not tender evidence, but I'm just speaking as far as general. It is part of evidence, is that correct?
Yes.
Okay. All right, so if you have a failed... Well, I'm not going to ask if, because I don't want it to sound like legal advice. When you have a failed photo lineup, that is considered exculpatory, is that correct?
It can be.
It can be, okay. And would it not help your defense to have that sort of document submitted to the jury if you were under the three-legged stool defense?
So the three-legged stool is how I explain when an element is missing
Okay,
in a crime.
okay. And
So if you kick out a leg of a three-legged stool, then it collapses. I use that in tons of my trials. Okay? I guess what you're asking is, should I have put in the photo lineup when I'm explaining that? I could have addressed it in closing argument in maybe one or two sentences. I could have asked the alleged victim the questions that I asked her. And the burden is on the state. I don't have to put in anything.
Correct. So basically what I'm asking is, it was a strategy of yours not to ask the victim if he was able to do an identification.
I asked the victim, you're saying I asked Mr. Payne if there was a photo lineup?
No, I'm asking, was it a strategy of yours not to ask the victim or the alleged victim if he was able to do an identification of your crime?
Yeah, there's a lot of nuance that goes on in some cross-examinations and some trials. I might have looked over and seen the jury was bored and about to fall asleep. I might have thought, well, I'm just going to leave this big gaping hole in the state's case.
What gaping hole? What gaping hole?
That there was a photo lineup and the state didn't have your positive ID on the photo lineup.
So I'm glad you stated that. At what point did the jury hear about that evidence? At what point did the jury hear that your client was not identified? What point did they hear?
So, if you're talking about specifically in the photo lineups, you'll have to reference the transcript.
No, Mr. McAdams, I'm asking, at what point did the jury hear that the client was not identified?
You'll have to reference the transcript. I don't remember exactly when it was referenced that you were not identified. You were identified by cell site data, you were identified by your car, You were identified by your co-defendant, who in the courtroom identified you in front of the jury. So the question is pretty much moot at that point.
Specifically, Mr. McAdams, I'm asking you, and I see you're doing the same thing. Specifically, when did it come across to the jury that your client was not identified by the victims in this case?
You'll have to reference the transcript.
Okay, and that's what I'm referencing to. What part of the transcript shows that?
What I'm saying is I don't remember specifically. You'll have to reference the transcript.
Okay, so I'm going to go to pardon me for a second, Mr. McAdams. Okay, specifically on page 477 of the trial transcript, and to break it all the way down, on page 479, your client specifically started speaking about not being identified, and for some reason you chose to stop that from being spoke about on the record. Was there a specific reason that you stopped your client from speaking about not being identified?
This was when you were testifying?
I just need a yes or no question. On page 479, your client,
context.
on page 479, your client started speaking about not being identified on the photo lineup, and you chose for some reason to intervene on that testimony. Was that a specific strategy of yours to stop your client from speaking about that?
I need some more context. Is this when you were testifying?
This was before the testimony. You know, we had the discussion without the jury being present. So the jury never heard about your client not being identified. Every time the jury was on the stand, it was always you're identified, okay? But specifically, when your client started speaking about matters of not being identified, you cut them off, you stopped them. Was that a strategy of yours to stop your client from discussing or putting on record that he was not identified? Was that a strategy?
Yeah, my strategy was to have you not address the judge in the court directly. It was to speak to me on things, and then I would share what I thought was in your legal best interest.
Okay. And your client and also the investigators did inform you that there was no identity by the victims themselves?
Eventually, Mr. Fain and Ms. Kennedy both made statements, and they were able to identify you. Not at the initial photo lineup, like right at the beginning of the investigation, but as the investigation unfolded, and then, of course, at trial, you were identified by them.
So I was identified, the petitioner was identified by both victims, is what you're saying?
Yes.
Okay, I don't remember that. Now, during the questioning of those victims, you stated earlier that it was strategy for you to ask one victim if she was able to do a photo lineup and was she able to positively identify your client, and then on the other victim not to ask that question. And you know, judging by the verdict of this case, by asking the victim if they were not able to identify your client actually worked with your defense. By not asking the victim the question of if there was a positive identity harms your defense. So this goes back down to the initial conflict that we was having, or that you had with the petitioner as far as identity. Were you protecting yourself from the text messages that you sent not being disclosed on the record, or were you actually using that as a strategy to try to win the case by not having that information exposed to the jury?
So one, I wasn't protecting myself from anything. I stand by every decision I made in this case. What was your second question?
Okay, so was you protecting yourself from the text messages that you stated to your client from being exposed in the fact that he was not identified? Was you protecting that information from being exposed to the jury, or was it a strategy of yours to keep that information that your client was not identified from the jury? Was that a strategy of yours to keep that specific information from the jury?
So I covered this earlier, okay? You need to listen, all right? If I don't ask that question, then I leave a thought in the jury's head.
Okay. And what thought was that?
Why wasn't he, why didn't the prosecutor ask him he was identified? Why didn't the defense attorney ask him he was identified?
Okay, so after the state had a first-time in-court identification of your client, and you have first-hand knowledge that your client was not identified.
So you're conflating two different things, all right?
What is that?
Not identifying somebody in a photo lineup, right, as the investigation starts is not the same thing as a in-court ID of the defendant under oath by an alleged victim in a case.
Okay, and if you were
that person identifies you, then ID is going to be met. Okay. In the courtroom.
Now, if you were to do a first-time,
I can make an argument. I can make an argument like, hey, how come you weren't able to identify him 5 days or 1 day or whatever right after this happened? That's an argument, but that doesn't invalidate an in-court ID.
Okay.
And if you were an attorney, you would know that.
What does invalidate a first-time in-court ID?
Not much.
You said not much? And okay, and what is the general information that is invalidated first time in court ID?
If a witness that has a plain line of sight on somebody and sees somebody and says that's the guy, then that's an in-court ID.
So something like total circumstances, totality of the circumstances, opportunity to view the perpetrator, and credibility to the jury. Does that sound something like, what would go against the first time in court identification?
Sure.
Okay, which it is. So, did it not come out during the alleged victim's testimony that the victim allegedly turned to the left, or the perpetrator allegedly turned to the left in the driver's seat? Was that not part of the alleged victim's testimony?
Mr. Payne?
I'm glad you asked. So it shows you have recollection. Yes, sir.
Yeah, on Mr. Payne, I believe the victim's testimony was that he pulls up, he asks you to get in his car, you say no, get in my car, and then so Mr. Payne gets in the back seat of that car, and he's going to presumably do a drug deal for marijuana, and then there's an attempt to rob Mr. Payne by the driver, and then the driver, when he said, well, you're going to have to shoot me, the driver shoots him. And so it would have been, if you're in the driver's seat, you would have to turn to your right.
Right being towards the passenger.
Get back to the middle of the back seat.
Okay, so right, when you say turn to the right, that means towards the passenger, is that correct?
Correct.
Okay, but you specifically highlighted that the victim did testify that the alleged perpetrator turned to the left. You highlighted
the left window?
Yeah, you highlighted that in the trial. You highlighted that the victim testified that the perpetrator, the alleged perpetrator, turned to the left. Excuse me.
Okay. Well, he might have been talking about his left. I don't know.
No, you specifically highlighted in the testimony, and you highlighted this for a reason. The victim said no. When you asked the question, well, do you mean to your left? Because you asked that same question in trial. Do you mean to your left?
Yeah.
Or do you mean to your right?
Off to the left.
And you specifically got the alleged victim to testify that the perpetrator turned to the left, meaning that you have the driver's seat, and you have the window here, you have the seat behind you, you had all of that testimony entered into the record, okay? So I'm going by the record, I'm not going by speculation. Now,
Sounds like I'm crossing them up pretty good.
okay, so when you got the testimony on the record that the alleged perp turned to the left, that skewed, the viewpoint of the alleged perpetrator. Is that not correct?
Yeah, he would have just been looking at the window.
He would have been looking at the window, and what else?
You know, I'm going to
Out the
object to
window?
relevance to this line of questioning as to how it pertains to ineffective assistance to counsel.
Yeah, this is not helpful for me as far as any kind of claim of ineffective assistance at this point.
Ma'am, the reason why I'm asking this question here is because the ineffectiveness come in with the first time identification. Mr. McAdams did not object to that. He did not object to the first time in-court identification, and that harms his defense. And no reasonable attorney would allow a client that was not identified to be identified in court with testimony of not being able to see who actually.
I mean, but you just cut to the chase and made a good argument.
Yes, ma'am.
But we've been talking about this for over an hour, and I had no idea where we were going.
Yes, ma'am.
So, I mean, you are going to have to be more concise. And, I mean, I feel like you're expecting me to know all this and make all these connections based on whether somebody turned left or right, and it's not helpful.
Yes, ma'am.
Okay? So just stick to what you are claiming he did that was evidence of ineffective assistance, okay?
Yes, ma'am.
You can ask him a question, and then after he's done, when you're making a final, a closing statement, you can tie all this up. But spending an hour asking all this about identity is just not particularly helpful, okay? You're almost being like way too specific in all this. All I need for you to do is argue as to how he was ineffective, okay?
Yes, ma'am. That's all. All right, so Ms. McAdams, in totality, it would harm your defense by not asking the question as far as identity. Clearly we can't speculate what happened in the jury room. All right, but ineffectiveness is what we're on. All right, you clearly didn't ask the victim if they were able to do identification. For some reason, there was a strategy of yours, you believe that it would work. Then it comes to a point in deliberation.
So I'm trying to ask Mr. Elam ask a question.
I'm getting there.
But you're testifying, so just ask him a question, and you're testifying is what you're doing, but just ask him a question and then explain it. Okay.
Ms. McAdams, you do remember the deliberation process of this case, is that correct?
Yes.
Okay, and that deliberation, it took some time, about 6 hours, 8 hours, somewhere around there?
It did. It was good for us.
Okay. When you said it was good for us, what do you mean by that?
Meaning they were belaboring different counts. They must have been arguing about stuff,
Which means that they had difficulties coming to a verdict, is that correct?
We got some counts mistried, and we beat some counts.
Okay.
That's a win in trying a criminal case.
Okay, you said you had some counts mistried. What do you mean by that?
Like they couldn't come to an agreement.
Okay, so that doesn't mean mistried, that means undecided, is that correct?
Yeah, undecided, because Judge Bishop did take a partial verdict.
Okay, so they were undecided. All right, now during that deliberation, do you remember the jury sending out a note saying that they cannot come to an agreement on the verdict?
That sounds familiar.
Okay. Do you also remember that there was a request there wasn't a request, but there was a determination that the jury required to be Allen charged. Do you remember that, or dynamite charge?
Yeah, the Allen charge?
You remember that?
Yeah.
And what is the reason for a dynamite charge?
So an Allen charge is, it just basically restates the law about, you need to listen to each other, but you don't have to give up your beliefs, and then we send them back in, the judge sends them back in, to deliberate some more.
All right, so Allen charge is basically to settle differences, to come to an agreement, is that correct?
Well, it just restates the law about deliberation, and, if they think they're done, they're not done.
Okay. Now, specifically directly after that Allen charge, roughly, it's very hard to tell, but in close proximity after that Allen charge, there was a request from the jury for a lunch break. Do you remember that?
Yeah, I think so, from looking at the transcripts.
Okay. But you do remember that there was a request for a lunch break?
Yep.
Okay, and the jury sent out a note for a lunch break. Was there a reason that note wasn't made a part of the record?
I have no idea.
So it wouldn't shock you that that note wasn't made a part of the record?
It would not shock me. I just don't know.
Okay, so in theory, if there was a request for a lunch break by a deliberating jury, normally that written request would have to be an exhibit in the trial transcript. Is that correct?
So I don't think so necessarily. I think that the questions definitely have to be, made court exhibits, but I don't know about scheduling, and I don't know about lunch.
So administrative, basically, anything substantive has to be made part of the record. Anything administrative, doesn't really have to be discussed on the record. Is that correct?
That sounds right.
Okay. All right. So after this, or during the instructions on this lunch break, the judge specifically instructed the jury not to discuss anything with anyone until they actually return back from this lunch break, and only after they return from the lunch break, they would be instructed to restart their deliberation. Do you remember that?
Yeah, it sounds familiar.
Okay. Now,
very standard.
Now, and again, this lunch break was directly after receiving an Allen charge. So they requested the lunch break to help them break the deadlock, okay? And the judge specifically gave them 30 minutes for a lunch break, okay? Now, after this lunch break, instead of giving them that time to re-deliberate, the judge instead called everybody into the courtroom. Do you remember being called back into the courtroom after the lunch break?
I remember being called back in, but I don't remember the timeline and if they were given time to deliberate. I don't remember.
Okay. All right, so just to refresh your recollection, the petitioner, went through the procedure, so the timeline is not an issue. So after this lunch break, you have the judge coming on the record asking specifically if the foreperson, Ms. Newton, if she received an instruction that was given at some point. What point, we're not going to determine that yet, but do you remember that the judge stated that on the record that he had given an instruction to the foreperson? Do you remember that?
I don't remember.
You do not remember that? Okay, so immediately after returning from the lunch break, the judge stated on the record, and I would like to refresh your recollection.
Mr. Elam, how is this any kind of evidence of ineffective assistance?
So basically, the jury was deadlocked. It was hung. They couldn't come to an agreement on the verdict, and they asked for a lunch break to help them deliberate.
Nothing to do with
After they come back from the lunch break, the judge stated on the record that he sent the instruction to them stating to fill in what you have, what you don't have, leave it blank. That instruction is nowhere on the record. It's nowhere on the record. It was done ex parte, and it was given to a bailiff, which you can't delegate that power to a bailiff. The bailiff can only do things on comfort and convenience.
But are you saying that he's ineffective for not objecting?
He was ineffective by not objecting to the ex parte communication of a deadlocked jury directly after an Allen charge. That is extremely coercive.
Well, but you don't really have to cut to the chase. I mean, you're taking so much time to get there, and it's...
Yes, ma'am, I apologize.
I'm not trying to make clear all this thing.
Yes, ma'am, I apologize. It's very hard to get to the point of...
I understand that a lot of this that we're going over this ground, and it's not clear at all what the relevance is.
Okay.
But, you know, asking those kind of questions, you know, we don't have a jury here, just, you know, cut to the chase and just ask him directly kind of about the fact that he didn't object or he didn't file any kind of, he didn't raise any kind of objection after that.
Okay, all right. So just so we're not losing bases on the ground, you know, I am arguing ineffectiveness for you not objecting. First of all, you know, and I was going to bring it up later on in a questioning. You didn't object to Newton being a part of the jury after she disclosed that she was close friends with Captain J. Baker of the Prosecutor Sheriff's Office. Was that a strategy of yours?
I don't remember.
Okay, so Ms. Newton stated for the record, and I did send her this into the evidence. During voir dire, she stated that she was close friends with Captain J. Baker, which is the spokesman of the Cherokee County Sheriff's Office. That same officer made a public statement about the guilt of your client on February 7th of 2020 about the case. Let me pull it up for you. Was it as part of your strategy not to strike her for cause?
I don't remember being aware of that information during voir dire.
Okay, so you're basically...
She could have had to, listen up, she would have had to have, during voir dire, answered a question and, I guess, provided information to where her mind was not fully impartial between the defense and the state, and she already made up her mind about your guilt, all that kind of stuff, or to be struck for cause. So it would have come down to a discretionary strike, which I don't know if I had already used all my strikes by the time we got to her. I just don't remember.
So after a person discloses that they are close friends with an officer on the same prosecuting sheriff's office, and you were to ask that person if she will be biased or not, is that not a question to reconstruct her as a juror?
So if she had already said that she can't be unbiased, or already made up her mind about your guilt or innocence, then that would have been a strike for cause, or I would have been able to ask further questions about that. Merely having a relationship with an officer is not enough for a strike for cause. So that it would have fallen to a discretionary strike, of which I only have 9.
Okay, so
you find why didn't you strike on somebody else that I thought was more beneficial for you? I don't remember.
So basically your position is you didn't find it reasonable to strike her for cause after she disclosed that she was close friends with the prosecuting sheriff's office?
He's already...
So try listening, okay? A strike for cause.
I mean, I'm already... We need to move on. I mean, he's already answered that.
Okay.
Okay?
Now, the reason why I asked that, Your Honor, may I approach?
You have to show him the one of things.
All right, so this is the AJC news post on the case of Captain J. Baker, the same individual that Ms. Newton stated that she's close friends with, painting the narrative with a picture of me posted online. Okay.
I'm going to say, or hearsay, Judge. Any of that's hearsay.
Okay, this part is hearsay, but as far as the disclosure of her close companionship to this same individual who publicly spoke about the case, and to have her become the fourth person of my jury, it is very possible that the two communicated as far as guilt, as far as information.
But you, unless you can prove that, I mean, I understand what your argument is.
Okay, and basically, I'm saying he was ineffective after learning that she was, and he was ineffective by not investigating into that companionship, not asking the questions needed. The only thing that he allowed was Mr. Overstreet to ask her, okay, would you be biased? After learning that she was close companionship with him, the only question that was asked is, would she be biased? And she said no. Mr. McAdams is ineffective by not furthering that question to determine if there was actual bias or if there was actual conflict with her being, on a jury. And with an investigation on myself, I found that this same person that she claimed that she was close friends with publicly spoke about the case.
Just for the purpose of the record, I object to that.
I got it. All right, let's move on.
All right. So, so basically, it was your strategy to save a strike from striking her after she disclosed that she was close friends with Captain J. Baker. It was a strategy of yours to not strike her. I don't believe he answered that question.
I mean, he explained that. It just kind of depends on where she fell
Well, yeah, that's the main issue. She actually became the jury foreperson, and she was.
have any control over that.
Okay. All right. So let's go back to the lunch break. All right. Now, during the lunch break, there was an instruction given to that foreperson, Ms. Newton, and specifically, we don't know what the instruction was because it was done off the record, but we do know that it was a supplemental instruction to the Allen charge, because the judge specifically stated on the record, did you receive the instructions from the bailiff to put in, quote unquote, put in, to fill out the verdict that you have reached, and any verdict that you haven't reached will be blank. Do you remember that instruction being given?
Yeah, that sounds familiar. The judge can take a temperature of the jury. They can bring them in and say, what counts are you, they can't say what counts, but how many counts? Do you have anything decided? They can ask that.
Yeah, they can ask that. I'm not debating that. But can the judge instruct the jury to stop deliberating outside the presence of the defendant?
Yes.
They can. So if a judge gives a jury
the judge can take the temperature of the jury. They can say, bring everybody in. Are you decided on any counts? Are you able? Have you reached a verdict on any counts?
Okay. So again, sir, that's not what I said. After the Allen charge, the judge instructed them, once you get back from the lunch break, you can continue deliberation. Instead, after we returned from the lunch break, the judge specifically stated that he gave an instruction to the bailiff to go and tell the jury to stop deliberating. From your testimony just now, you're saying that it's permissible for a judge to stop a jury from deliberating outside the petitioner's presence. That's not a violation of the right to be present.
The judge can bring the jury in. By definition, they have to stop deliberating if they're coming in the courtroom. If all 12 of them are in that room, they cannot deliberate. If the judge brings them in, they, by definition, have to stop deliberating.
Correct. Okay, so I think you're averting the question a little bit. By manifest necessity, you can stop a jury from deliberating.
So if I object, Mr. McAdams' opinion about the legality of the judge's position is not really important. What's important is what he did and why he did it and why he would.
Correct. Correct. So the reason the judge stopped the jury is because they were coming. Now the main problem that the petitioner is alleging here is ineffectiveness for you not objecting to that ex parte communication. Why did you not object to that ex parte communication?
Because the judge can take the temperature of the jury, he can bring them in, he can have the bailiff say, y'all are coming in, he can ask them what their status is in deliberation. He can ask
Correct. But can the judge ask a bailiff to tell the jury that?
Because justice is asking Mr. McAdams.
That's the issue that the petitioner has faced.
All right, objection.
Okay. Specifically, the judge delegated the bailiff to go into the jury's deliberation room and to instruct them to put in, to fill out the verdicts that they have reached and to leave verdicts that they haven't reached blank. Why did you not object to that ex parte communication when it was disclosed?
I didn't think that it was inappropriate. I thought that the judge was doing his job. He can bring in the jury and take their temperature.
Okay, so you keep saying check their temperature, sir. We're speaking about after an Allen charge. We're not speaking about during the beginning of deliberation after they sent out the first note saying that they were home. We're talking about specifically after an Allen charge, which is a very, very, very significant charge. Okay? After an Allen charge, the jury is basically, that is a part where there are most, any type of word incorrectly spoken on or said can be considered coercive, okay? So if there's any other charge after that, from your understanding, that does not violate a petitioner's right to be present if it's giving off the record and outside of the presence of your client.
So the fact that the judge said, tell the bailiff, I'm gonna bring y'all in and check where you are on individual accounts. That doesn't violate, the Court of Appeals determined in this case that didn't violate your rights.
Okay, so I'm gonna actually read off and we're gonna go from that and see if that refreshes your recollection of the specific instruction, because you state that the judge is checking the temperature of the jury, and that's fraud upon the court to say that.
Mr. Elam,
Yes, ma'am.
you cannot make brief comments to your witness like that. That is very, very improper and bordering on contempt of court, okay? Don't make snide comments to him again. Don't comment on whether or not you believe his testimony. Don't do that. We don't do that in a court of law. You don't speak that way to a witness. And don't speak to him that way again, okay?
All right, so Ms. McAdams, directly after the lunch break, it states here, okay, you can bring the jury in. Ms. Newton, is that right? Yes, sir. You are the foreperson of the jury. Yes, sir. My understanding is that you have reached verdicts on some counts, but you have not reached verdicts on other counts. Yes, sir. And you received the instructions through the bailiff to put in, to fill out any verdicts that you have reached, and any verdicts that you have not reached will be blank. Yes, sir. And you've done that. Yes, sir. And, okay, if you would please hand the verdict form to the bailiff, and the bailiff will transmit it to the bench, please. That basically explains that whatever instruction that the judge gave the bailiff, that foreperson abided to that instruction and completed the verdict form from that instruction. So whatever that instruction is, no one knows about that instruction because it was done off the record. And not only is the petitioner saying that it was done off the record, but the trial court themselves admitted that it was done off the record outside the presence of the defendant. So my question to you is, why did you not object to the judge saying that he gave an ex parte instruction to a bailiff to deliver to a hung jury? When the very first time you heard that from the judge, why did you not object? As far as your client not being present for that instruction.
Well, I thought there was a possible benefit for you. What if they were not guilty on 5 counts and hung on 7?
So basically, you gambled with the right to be present, and hope that you would get a positive benefit from that. You gambled with the right to be present, the absolute right that you cannot waived without, you know, without it being on the record, you gambled with that right, hoping that you would benefit from it?
No, I didn't gamble. I didn't see a legal objection if there's a benefit to you for being acquitted of counts or all counts that they made a decision on and hung on the other ones.
Okay.
Then I don't see a legal objection.
We don't know the outcome yet. I'm specifically asking about the ex parte communication with the hung jury after an Allen charge. When the judge released that he gave this instruction, and you know because you were there, that the instruction is done off the record, and it was outside of your presence. When the judge gave that supplemental statement stating that, hey, I delegated this power to the bailiff went to the jury and said this to him, or allegedly said this to him, since you was not able to be there, it was an interference by the government, since you was not able to hear the actual words that the bailiff said, which could have been coercive to a deadlocked jury, why did you not object once the judge released that information that an ex parte communication happened with a bailiff?
It could have just as easily been beneficial to you, and I did not see a legal objection to
So what benefit?
the judge handling his jury and bringing them in and taking their temperature.
What benefit?
I don't see a legal objection.
What
Neither does the Court of
benefit?
Appeals.
Sir, what benefit would you have for a bailiff to instruct a hung jury ex parte? What benefit would that be?
I wasn't aware of any instructions that the bailiff gave the jury other than I'm going to bring them in and check their temperature.
Okay, so
Not aware of any other instruction, any objectionable instruction that a bailiff made.
okay, so you're saying basically you was not aware of the fact that the judge put this on the record and you received the instructions through the bailiff to put in, to fill out any verdicts that you have reached, and any verdicts that you have not reached will be blamed. You're saying that you was not aware of that?
I am aware of what the judge said on the record. Yes, I'm aware of it.
Okay, and you are aware that instruction, that supplemental instruction of what possibly was said is not administrative?
I disagree that it's not administrative. The judge can bring a jury in. He can say, do you have some verdicts on some counts?
Okay, so is that acting if you have...
Maybe the jury told the bailiff, you know what, we're tired. We've got 5 counts.
Okay, so that is what I'm asking.
And the bailiff has to disclose that information to the judge, and the judge might say, well, write them down.
Okay.
That might have been what happened. I don't know.
Okay, so even if...
I didn't see a legal objection at that stage, and the Court of Appeals determined that wasn't prejudicial for you, and that I was not ineffective for doing that.
Okay, so even if, my question for you is, even if that is still supposed to be a part of the record, if the judge is stopping a jury, that must show on the record that how he stopped the jury, it has to show on the record if there's a manifest necessity to stop a jury from deliberating. That has to appear on the record, okay?
Jurors are brought in all the time for scheduling, to check their temperature, to see if there's any issues with anybody picking up kids. You don't know any of this because you're not an attorney. You don't try to.
So, Mr. McAdams, my question for you, you keep saying check the temperature of the jury. I understand why you keep saying that, but the thing is, Mr. McAdams, that's not what the record reflects. The record reflects that after a lunch break...
Mr. Elam, you're testifying. You can't testify. You have to ask him questions.
Okay, Your Honor, here shortly I would like to actually testify. That's the only way to get this in. But my main question is, why would you not object to an ex parte communication with a...
He's already answered that about 4 times.
Yeah, but he has not answered as to was it a strategy.
Yes, he has.
Okay, all right. So, Mr. Adams, it's clear that you stated that it was... You hope for a benefit by not objecting to your client's right to be present, that it would be beneficial for your defense.
Was that a question for me?
Yes, sir. Yes, sir. I just want the record to be clear.
Did you ask it again?
I just want the record to be clear that you are saying that you gambled with the right to be present, hoping that it would be beneficial to the client for a favorable outcome by not objecting to a bailiff instructing a jury ex parte.
Mr. Elam, I've answered this question multiple times, multiple different ways. And what I can tell you is I didn't see a legal objection to what occurred with the judge bringing the jury in to check their temperature. I don't know what was said, but I didn't see a legal objection that I could make for you.
Okay. So, and that's the reason why I keep going back, is because he's testifying saying that he doesn't remember, and my question is directly from the record. The record clearly states that.
There's unobjected to the argument testimony during your time.
Okay, I'll testify to it. All right, so basically, Mr. McAdams, as far as ineffectiveness, you didn't object to the ex parte communication with the jury. It was a decision that you made as far as strategy. I don't know because you're not answering the question. But once you did receive the supplemental statement from the judge, your testimony is you didn't object. You didn't find any valid reason to object. I'm not going to ask the same question. I'm closing.
You're testifying.
Okay. I have no further questions for you.
Do you have any questions as far as? Briefly, Judge. Mr. Adams, we'll start with giving some of your background information on the record. When were you barred with the state of Georgia?
June 3rd, 2016.
And since that time, rough estimate, what percentage of your work has been in criminal defense?
99.9%.
Prior to handling Mr. Elam's case, had you been defense counsel on armed robbery cases?
Yes.
Were you appointed or retained on Mr. Elam's case?
Appointed.
At what stage of the proceedings were you appointed?
I was appointed at the warrant stage.
So then you were the attorney at the preliminary hearing?
I was.
At the preliminary hearing, did you have full discovery from the state yet?
No.
At what point in the proceedings would you have full discovery from the state?
After the case was indicted, I filed a discovery motion, and the state served me with discovery. There was also a supplemental discovery. It was served throughout the pendency of the case. Some cell site data came in late, and some GBI stuff came in late, but I was receiving, and I also received information from my client during the trial, which I disclosed to the state using cross-examining the state's expert witness. So I was getting discovery pretty much after indictment.
So those text messages that you sent to Mr. Elam 2 days after the preliminary hearing, were you basing that solely off of the evidence that you heard at the preliminary hearing?
That, and I believe I had maybe one open records request report, but again, there were multiple reports from different agencies that came in and search warrants that hadn't been executed yet and stuff that I didn't have yet at the prelim.
So just to clarify, the text messages that Mr. Elam was complaining about on direct examination, it's fair to say that you were operating on limited information at that point, correct?
Yes.
You mentioned on direct examination that there was a satisfaction with counsel hearing. What was the result of that hearing?
Well, there was one in front of Judge McAdams, and she heard Mr. Elam's concerns and did not remove me. And then there was another one in front of Judge Bishop, who was a visiting senior judge who ended up trying the case, and he did not remove me either.
Were Mr. Elam's concerns mainly over trial strategy?
I don't remember specifically what he said. It might have been trial strategy. It might have been that I didn't object, to the identification, and that a prelim wasn't held on the hit and run case, which that warrant was dismissed by the solicitor's office, which he could never basically reconcile with. I don't remember exactly what he said at either one of the satisfaction to counsel hearings.
Did Mr. Elam ever tell you that he had hired private counsel?
I think he told me a couple times that he was going to hire people, and that he maybe left me some voicemails that he was gonna bond out, and nothing ever came of it.
Did a private attorney ever file an injury of appearance in this case?
No.
Do you recall Mr., talking about Mr. Fain and his lack of identification with this?
I would like to object to that, if it's relevant.
I'm sorry.
I'd like to object to the question if it's relevant.
Okay, I'm going to object to the second one.
Do you recall Mr. Fain was close to making identification, but decided not to because the person in the picture was not wearing glasses?
That sounds familiar.
If that had been the case, would that have contributed to your trial strategy for not wanting to inquire further into the photo lineup at trial?
Absolutely. I don't want to bring that up, that it might be him, but he had glasses or didn't have glasses.
And moving to the issue of the verdict and the judge's instruction, do you recall that before the jury was released for lunch, there had been a discussion that the judge intended to take a partial verdict at a specific time during the day?
I do not recall.
So the record will speak for itself on that matter, correct?
Yeah, whatever the record said, that is correct.
I have no questions for Mr. McAdams.
I would like to recall.
I think you need to go ahead before we do this. Okay, go ahead.
Okay. Mr. Adams, you stated that you said that you didn't want to bring up the fact that the difference of the glasses, okay? Now, would that be an issue if that the individual was wearing glasses during trial? Wouldn't that be an issue then?
So, I guess my answer to that question was, if Mr. Fain had said, that looks like him, but he was wearing glasses, so I don't know, that's a partial identification. I'm not going to bring that in. I'm not going to do the state's job for it.
Okay, so you said you're not going to do the state's job. Now, I asked Mr. Overstreet earlier specifically about that photo lineup, to even see the type of photo that it was, that was inside of the photo lineup. That photo lineup, was that provided to you by the state?
Yes.
Okay, so the photo lineup was provided to you?
Yes.
And that photo lineup did not have a positive identification on it, is that correct? Regardless of glasses or anything, it did not positively, it doesn't have your client circled and positively identified, is that correct?
Yeah, so you're under the impression that it has to be either 100% or nothing, and that's not how it works. If it's a partial identification, then it could be problematic for the defendant in trial. So I'm not looking to put that information in.
I'm asking you, on that photo lineup, does it have your client circled and identified? That's the question I'm asking.
I don't think so.
I don't think so. It's not a yes or no question, sir. Answer. Okay, so the client wasn't identified. We already established that the victim failed to ID your client, right? Was it a strategy for you not to give that failed identification document to the jury to create what is called reasonable doubt?
Yes, it is a strategy because if there is a partial identification, then the jury can take that as evidence.
Okay, so in a photo lineup, there's a such thing as partial identification. Like you can circle someone halfway.
Yeah, you can write 60%. You can say, well, it kind of looks like him. I didn't see his mouth, or I didn't see his eyes, or whatever. That he has a beard like that guy. I mean,
okay.
It can be subjective. And so if I felt like it wasn't to your benefit to ask Mr. Fain, like, hey, you didn't identify Mr. Elam, isn't that correct? And then he says, oh, well, I knew it was him, and he just had glasses on, or didn't have glasses on.
Okay, so...
And then it's a big problem.
Okay, so if you have a photo lineup of an alleged victim saying that they're not 100% sure that this is the person, regardless if it was 50%, 60%, 20%, however you go about it. If you have doubt that this is the person that committed the crime, is it not beneficial to submit that into evidence in a case where identity is a question?
So, you were identified other ways in this case first.
So that's not the question. I'm asking you, is it not?
I'm answering your question.
Is it not a part, would it not help your defense, or would it help your defense to submit the document? I'm not asking about other identification.
I believe Mr. McAdams was trying to answer Mr. Elam's question, he was allowed to do so, and Mr. Elam had a follow-up.
You need to let it answer, and then you can, after he finishes talking, you can ask another question.
Yes, ma'am. I would like the record to reflect that I'm being prevented from asking the actual question. I'm asking him.
Being prevented by who? By me?
No, ma'am. By the testimony and by the objection. The objection it doesn't touch bases on actually what's trying to be
You're
established.
interrupting your own witness. Like that's the frustration, is that you're interrupting your own witness. Let him answer. And then if you have, I feel like you're not listening to what he says, you just want to keep talking.
Yes, ma'am.
Listen to what let him finish and listen to what he says and then ask the question. But I feel like you're so busy trying to argue with him that you're not even listening to what he's saying. That's why you're asking the same things over and over. Just let him finish. That's the way we do things. Okay, you let a witness finish explaining his or her answer. Okay? All right.
So, I guess I need to be reminded now, Judge.
Okay, so I can remind you.
I had the answer, if Mr. Elam would re-ask me the question.
Okay. So my question is, and if you could please keep the question, or keep the answer within what the question that's being asked. In a case where identity is that question, right? Is it deficient of an attorney not to submit a failed identification document? What part of not submitting that document helps your strategy in a case where a person is not identified? What strategy is that?
Yeah, so I think I've explained that multiple times. So if it's a partial identification, I'm not going to do the state's job for it. I'm not going to allow that witness to explain, you know what, now that I look at it, that is him. It's unequivocal, it was definitely him. I'm not going to open that door for the state. So I'm not going to ask that question. I'm not going to put the pictures in if I feel like it's not in your best interest.
Okay, so you said you're not going to open that door. So once the state opened the door and did the first time in court identification, that door has been already opened. In order to, in a case where the evidence is even, okay, I'm sorry. After that door is opened by the state, them asking them to do a first time in court identification, did it not help by entering that document? You stated that, you're not going to open the door, but once the state opened the door, which they opened the door first, did it harm your case by not submitting the failed photo lineup?
No, it did not harm my case by not submitting the failed lineup.
And how is that? How did it not harm your case by not submitting the failed photo lineup?
So, first of all, in-court ID is required in any jury trial, okay? So, if the victim identifies you in the courtroom, then ID is going to be met.
Okay.
But if there was a contradiction in the evidence, like he couldn't identify you initially, I'm going to bring that up. If there's a partial identification, I'm not going to provide assistance to the state in your identification.
Okay, so that's my next question. Why did you not bring it up in front of the jury that your client was not identified? Why did you not bring that up?
It wasn't that's not him. It might be him. It's a partial identification.
Sir, both victims stated that they did not identify.
You have to ask questions.
Okay, so my question is, why did you not ask the victim about the identification. Regardless if it was a partial, failed, if the state bolstered a first-time in-court identification, the only defense to that is credibility, attacking his credibility. Why did you not ask him that question? Why did you not ask him, hey, Mr. Fang, was you able to identify my client?
This isn't an accident.
He never answered that question, Judge.
I'll allow it.
Why did you not ask him the question, was you able to identify my client after a first-time identification in court? The door's been open. What part of your strategy was it to leave that question and ask him, did you do a photo lineup? You asked him, did you do a photo lineup? And you received a positive answer. Yes, I did. But you stopped your questioning right at that point before you got the information that he failed that photo lineup. What part of your strategy was that to leave that information out?
So I've explained this to you multiple times, you need to listen, okay? If it's a partial identification, which it sounds like it was, then I'm not gonna put that affirmative evidence of your identification in the record. That is gonna be the state's burden to meet your identification. I'm not gonna assist the state.
You're saying a 40%, 30% identification, that's affirmative to you?
If it's any sort of partial identification, I'm not gonna assist the state.
Sir, I would hope that you will refrain from keep saying it.
You need to ask the question.
Okay, so you state affirmative identification. If a person points out a person in court and says, I'm 100% sure that's him, and you have a photo lineup that says you're only 30% sure, or 40% sure, or 50% sure, would that not help your defense by presenting that information to the jury for them to determine if it's valid or not?
Not necessarily, no.
Why is it?
Because it's the totality of the circumstances for your identification.
That is
So if you've got an in-court ID and you've got a partial out-of-court ID, that's not beneficial to you.
So is it not beneficial after receiving testimony that the victim or alleged victim could not see the identity of the person from the way that the perpetrator turned? Because you boasted that testimony out of court, that the perpetrator turned to the left and there was no way possible to see the face of the person. You got that testimony out of the victim, right? So
sounds like that was for your benefit.
So why, if it was, why did you not present the failed photo lineup to the jury if it goes by the totality of the circumstances? And you just boasted testimony that the victim was not able to see your victim or your client. Why not present the failed photo lineup? What strategy is that? What strategy is that?
I'm not going to provide beneficial evidence of your identification for the state.
So, sir, I would like to go back to the record.
First, use your identification.
You're saying the beneficial evidence. There was no positive ID, and we got testimony from the. Okay, so there was no positive identification. So your testimony here today is failed photo lineup would be beneficial for the state. That's what you're saying.
If it's a partial identification, like it's like that guy, but he didn't have glasses on, so I'm not 100% sure. That's not beneficial for you, for your defense attorney to put in. Okay, and was it a strategy of yours to withhold that actual photo lineup from your client? Withhold it from my client? No, you got everything. You got all the papers. So you're saying that you provided the photo lineup from Damion to your client? Yes. Okay, so on the record, during the trial, during testimony, your client asked the prosecutor for a copy of that photo lineup, and the prosecutor stated that that lineup wasn't provided. Why did the prosecutor say that? Now that's him.
I'm a speculation.
I need to be clarified. How is that speculation if it's
I have to say objection.
Okay, so from the record, the prosecutor stated that there was no identification. There was the photo lineup's not there. What was your strategy as far as allowing the prosecutor to withhold that evidence? What strategy is that?
Allowing a prosecutor to withhold evidence?
To withhold the photo lineup. What strategy is that?
The prosecutor can put up whatever evidence in that he wants. If he doesn't put in evidence that is beneficial for you, I'm not going to make him put it in. So
if there's a failed photo lineup, and that is exculpatory, which we got testimony of from the prosecutor. If the prosecutor fails to release that information or that document, that is considered a Brady violation. Is that correct?
It would be, but I got the document and so did you.
Okay, so your client basically committed perjury in the trial when he asked for the photo lineup.
You have to ask the prosecutor trying to charge him with perjury about that.
Okay. All right. So at what point did you provide the photo lineup to Mr.
No idea.
Okay.
You got every piece of paper that I was allowed to send you to the jail.
Okay, and you're stating that you're stating for the record that Mr. Overstreet provided you with that photo lineup, that failed photo lineup?
Yes, he did.
Okay, and you also stating that you did not submit that failed photo lineup to the jury?
No, I didn't.
Okay, and that was part of your strategy not to submit that failed photo lineup?
Right.
Okay.
You might have been convicted because of other crimes if I had done that.
And what other crimes would you be convicted of for a failed photo lineup of diamond things?
Well, somehow they convicted you of the armed robbery, but not the ag assault.
And how do you believe that happened?
I have no idea.
Okay. So with the...
But if you're pointing out at somebody, that's an ag assault.
I'm glad you stated that. Now we can get...
If it's somebody that's
Okay. I'm glad you stated that. Now we can get to the ex parte part of it. Now, during the structuring of the partial verdict, you stated that you caught Mr. Overstreet leaving the courtroom, and you specifically asked him about the hung count. You stated that you asked him, and he...
After sentencing.
Sir, if you can let me finish. You asked him specifically if he intended to retry the count. Is that correct?
Yeah, after sentencing.
Okay.
We had a conversation. I'm just asking, you did ask him if he intended to retry the count. Is that correct? Yeah, but you said something about, like, during the deliberation or something. It was after sentencing.
Okay. So, after sentencing,
he could have retried you on the counts that were hung.
Let me stop there. How many more questions do you have?
So I have questions for Mr. Clark too as well. In order to...
How many more questions do you have for this person?
I'm closing him. I have roughly 7 or 8 questions left. It's not that much.
When he finishes, we're going to take a break.
Definitely.
I'm going to hear from Mr. Kingdom, and I don't know if we'll finish this today or not.
Absolutely, that's fine. That's absolutely fine.
All right, we'll finish up. I'm not trying to limit your recall, so Mr. McAdams, I just kind of needed to know where we were.
It's fine. I'm fully aware of... All right, so you stated that you came across him leaving the courtroom. Now, when you discussed that intention to either try the counts, retry the counts, you testified on the motion for new trial that you did not disclose that communication with Mr. Overstreet to your client. Was there a reason that you didn't disclose that conversation to your client?
Yeah, I didn't think you would object to counts being dismissed and were hung.
So you specifically spoke about no crossing the charges, leaving the courtroom with Mr. Overstreet.
Yeah, the prosecutor in all process charges. I said, are you going to retry him on the counts that were hung? And he said no.
Okay, and you didn't
find... that's to your benefit.
Okay, and you didn't find any reason to discuss that those, dismissing those counts with your client. You didn't find any sort of, right to be present or right to be informed. You didn't find any of that being proper at that time after discussing that with the prosecutor to, hey, let me inform my client that they're dismissing these counts. You basically waive the right to a jury trial for your client.
I didn't feel the need to discuss with you that counts were going to be dismissed, and the rest of the counts were going to be dismissed.
So you basically waived the right to a jury trial for your client.
Well, the state doesn't have to bring a case, and so you're not entitled to a jury trial on counts where the state is going to dismiss the counts.
So if you put your client...
The state can show up and say, we're not going to present any evidence.
So if your client is in jeopardy of those counts, if your client went to trial for those counts, and the jury could not find a verdict for those counts, is the proper remedy to mistry those counts, or is it to no process counts?
The judge could have mistried those counts.
No. I'm not asking could have. I'm asking what is the proper procedure?
I'm answering your question.
What is the proper procedure?
I'm answering your question.
If the jury cannot unanimously agree on a verdict, what must happen on the record that at that specific moment for those counts? What has to happen on the record for those counts?
Nothing has to happen at that moment on those specific counts. The state could have tried you on those counts on a indictment with just those counts on them later on.
Yes, but you would have to declare
mistrial. Not to do that.
But you have to declare.
I wasn't going to get in the way of that process. You were getting counts dismissed.
Okay.
So you could have been convicted on later on. And I did that for your benefit.
Okay, so you said that you did that for my benefit, but on a motion for new trial, you stated that you were unfamiliar with the law on mistrial. So now it seems that you are familiar with the law on mistrial, but at the motion for new trial, you stated that you were unfamiliar with the law on mistrial. And specifically, it states that you stated that the judge should have asked for me to be present during that conversation of accepting that partial verdict and how you were going to dismiss those counts, because your client has a right to be present. Your client has a right to due process. And you cannot waive it. You cannot waive that. You cannot waive it. So I'm not finished with the question.
You're testifying. You haven't asked a question.
Okay.
Let him respond if that's what maybe that's will clear up whatever it is you're trying to testify / ask. Go ahead, Mr. McAdams.
So two different things. The counts were dismissed after sentencing, not in any sort of deliberation. The judge took a partial verdict. Those counts stood until they were dismissed.
When you said they stood, what do you mean by stood? Do you mean they were in limbo until sentencing?
Could have been retried. They could have been mistried, and you could have been retried on.
Okay, you said they could have been mistried. What was the position of the charges before sentencing? What were they mistried? Were they in legal limbo? Was they no pros? What was the position of those charges before sentencing?
They weren't no pros until after sentencing. They stood. I don't know if they were considered legally mistried at the time.
You said they stood. You said they stood.
But he took a partial verdict.
Okay.
He took a partial verdict on the counts where you were convicted.
Okay, he took a partial verdict on the counts where I was convicted, but what was the position of the charges that was undecided? What was the position?
I've answered your question, Mr. Elam.
Okay,
you can try listening.
They was in legal limbo, okay? So, is it your understanding that, are you familiar with the rule on manifest necessity? Are you familiar with that?
No.
So you're not familiar with manifest necessity?
No.
Okay, so understood. So you would say that it's deficient of you to not understand what a manifest necessity is.
I need more context to answer your question.
I asked you, it would be deficient of you to not know what a manifest necessity is.
Judge, whether or not Mr. McAdams was position is up from the correctional side, second and
It's been answered also.
Okay. All right, so basically, we established that you don't know what a manifest necessity is, okay? All right, so after the charges are not decided, they're hung, we go to sentencing where, did you ask the question before sentencing if the state intended to retry the counts, or did you ask that question after the sentence was imposed?
After the sentencing was imposed.
So after the court imposed the sentence, then you ask the state if they was to retry the count. Are you familiar with with jurisdiction and things like that?
Yes.
Okay. Are you familiar with the fact that the court does not have jurisdiction to impose a sentence if the verdict is not finalized?
The court can only impose a sentence when the verdict is finalized.
And you answered that question in a positive or in a negative. You are familiar with the fact that a court lacks jurisdiction to sentence until the verdict is actually finalized?
Right.
Okay, I'm glad you asked. All right, so if you ask the question as far as the no pros after sentencing, after the sentence was imposed, it's easy to say that the verdict was not finalized during the moment the court imposed the sentence. Is that correct?
The verdict was finalized on the 2 counts you were convicted on. And that's what you got sentenced on. You didn't get sentenced on any counts that weren't finalized.
The indictment alleged 13 counts. You can't leave out, you can't say, well, these are final and these are hung. I'm speaking about the...
If you were an attorney, Mr. Elam, you would know that you could be sentenced on 2 counts where you are convicted and not sentenced on 10 counts where you are not convicted.
Right, and which is considered a partial verdict, but the counts that's hung have to be finalized. It cannot be in legal limbo. And I don't want to be tested. I don't want to test...
That's incorrect, and what the Court of Appeals found is you were not prejudiced by any of that process.
Well, is it true that the Court of Appeals found implied consent to the no pros, not from your conduct, but from the appellate attorney?
I'd have to look at the opinion.
And what does no pros 17-8-3, which is no pros, or the statute on no pros, what does that require in order to be entered?
I don't know.
Okay, so you don't know the statute? You don't know the statute 17-8-3 or 17-8-3? You don't know the statute?
So I would have
to take a look at it.
What the law is. This is for determining what is actually considered and not contributed to his against.
I don't really understand how this is
So ineffective, it would be ineffective because it directly impacted the outcome of the verdict. They used the no pros to finalize the verdict, and the lawyer, you can't object to something you don't know about. So if you don't know that it requires the defendant's consent, and you go to a prosecutor, leaving the courtroom, and you ask him if you're going to no pros something, that statute specifically states, and is not ambiguous.
You didn't want them to dismiss those other counts? Is that what you're saying?
What I'm saying is it violated my right to a trial by jury, because I have a right to that. And for you to go to a prosecutor, leaving the courtroom, and ask him about those counts, and then not disclose that conversation to your client and just say, hey, I accept that benefit, it violates the defendant's right. That's an absolute right. It prejudices me because I have a right. That's a right that has to be waived by me. I did not waive that right. Just like I didn't waive the right to be present during the instructions to my jury. That's an absolute right. That's a right to be present. You cannot waive that.
I understand that.
Okay? So you waive that right and hope that I would feel I benefited by that, by them dismissing that count. Because a no pros is not really a benefit. Okay. So a no pros, you stated earlier, that you can be retried for that, for a no pros. Is that correct? For the charge of a no pros?
Right. They can re-indict within 6 months.
So you stated for the record that it's beneficial for the state, for your client to be no pros? That's beneficial?
Yes.
Okay, what benefit is that? If you can be retried for a count, how is that benefit your client?
The count's dismissed.
Is it dismissed with prejudice, or is it dismissed temporarily?
It's dismissed forever unless the state reindicts in 6 months, which they rarely do.
Okay, so...
Especially after having such trouble in the trial.
Okay, so you said such trouble with the trial. What type of trouble?
What is that?
Well, I think they thought their case was made in shade. I'm sorry, Judge.
I just don't know what this has to do with his claim of ineffective assistance.
Well, it has to do with ineffective assistance of counsel, Judge, because the issue in the trial was identity, okay? And with his deficiencies, they're not minor, it's not harmless because the evidence is so weak. And the verdict explains that. It's a full exoneration with evidence bearing intrinsic. Same similar transaction. I'm fully exonerated of one charge to say any violation would tip the scale.
Okay.
And that's the harm. The harm is by not objecting to a case that you know that the evidence is weak in, any type of violation of the defendant's rights can tip the scale. And it's clear because the hung counts are elements that's required in armed robbery. You can't arm rob without placing a person in harm.
I understand that.
That's why they merge together.
Okay.
So he's deficient by not objecting to these errors. These errors played a huge part in creating what is called an inconsistent verdict, which Georgia still recognizes.
All right, ask him questions.
So, Mr. McAdams, you basically, you went through most of my questions. The only question that I feel like you answered correctly is the last question I asked you.
I've already asked
As
you
far
to comment on the credibility.
Yes, ma'am, I'm sorry. So, as far as 17-8-3, no problem. You stated that you're not familiar with that. When you asked the prosecutor if they intended to retry the count and the prosecutor said no, you decided not to disclose that conversation with your client because you felt that it was beneficial. Is that correct?
Correct.
So, and you're not familiar with the absolute right that must be waived on the record to a right to a trial by jury. You're not familiar with that right?
No, I'm familiar with that right.
Are you familiar with the double jeopardy?
I am familiar with double jeopardy as well.
And you do know that are you familiar with that skips over double jeopardy, is that correct?
I don't think it skips over double jeopardy. I think you still have the ability to have a jury trial if the state brings the case back.
Yes, if they bring it back to a properly entered no prosecutor,
If the
right?
state reindicts, then you can have your jury trial. If they don't, the count is dismissed forever.
But that's the problem. That's
Your benefit.
that's the
Don't testify.
Okay.
Ask questions.
So the question is, in order for the state to bring back that charge, they either would have to mistry the count, or they would have to properly enter a no pros.
Right, it won't come off the trial calendar. It would have stayed on Judge McAdams' trial calendar, those counts, and until the counts were null pros or pled
Okay.
or dismissed.
Or mistried, is that correct?
No, mistrial, they would have stayed on the trial calendar.
Okay, so no pros is just a pausing of the prosecution, is basically what you're saying.
No, it's not. It's a dismissal.
Okay.
It's what you want in any criminal case.
So so basically your testimony or your position is you want a defendant to get a no pros.
100%.
Okay, so that is an outcome that you hope for in your trial, to get a no pros.
Sure.
And not a not guilty.
If it goes to a jury, of course I want it to be a not guilty, or I want a directed verdict of not guilty.
Okay, so your client's case. Okay, so your
But if the
client.
count's being dismissed, then that's to your benefit. I'm not going to object to that.
Okay, so your client's case went to a trial by jury, and that jury failed to anonymously vote guilty or not guilty on that count. And your testimony, your position here is you're stating that it's
it's your duty to get a no process in a case. That's what you're saying.
That's what I want in most cases. What I can tell you is most cases that are retried are convictions. Because in the state has solved all the problems that happened during the first case, and all the witnesses are ready to go, and they've got their ID, and everything's unequivocal.
Okay, so I just want the record to reflect that you stated that it is your objective in a jury trial to get a no process. That's clear. All right, no further questions. No further questions, John.
Okay, anything further?
No.
Okay, all right, can Mr. McAdams speak to Steve?
Yes.
Okay, all right, thank you, Mr. McAdams, we appreciate your patience and participation today.
Thank you, Judge. Have a good day.
Okay, thank you. All right, we are going to take about a 10-minute break, and I want to hear from Mr. Kingdom to see how far we can get with this case today. We will, Mr. Elam, just hang tight. Hopefully that I'm trying to try to finish up today. Do you feel like you'll take about as long on Mr. Carter as you did on Mr. McAdams?
Well, Mr. Clark, his part is direct. is right here. Well, everything is on the record, but it's not going to be that long. But I don't want to put a time limit on it.
I understand. All right. And we will take a break and try to get, try to get the Mr. Kingdom, try to get him completed, and then we'll call you back out, okay?
What now? Roughly that's in about another hour for Mr. Elam.
To finish?
I think once with this case here.
Oh, I'm not sure how long Mr. Kingdom's going to last.
All right. Well,
Okay, is there any witnesses for Mr. Kingdom? Okay, so it shouldn't take that long.
Okay.
Unless he's just as talkative as you.
coffee.
Okay, yeah.
Yeah.
Go ahead, get your coffee.